Good morning once again to all of you. I am happy to welcome you on behalf of the Association ARBITRI to the 8th Sarajevo Arbitration Day. I am truly delighted to see you all today after 2 years of online format. Firstly, I would like to thank to our partners and sponsors for supporting this conference, Arbitral Women, Delegation of the European Union to Bosnia and Herzegovina, and the European Union Special Representative, GIZ, Baker and McKenzie, Knotzel, Wilmer and Hale, and Nikčević and Kapar. Also, may I thank each of our speakers for taking part in this event. The quality and caliber of speakers this year is outstanding. The theme of this year's conference is Making Sense of Changing World, Energy and Construction Dispute Resolution in Sustainable Future. BH is at the crossroads, facing some very challenging and consequential questions. How to comply with the international energy transition obligations while remaining attractive to foreign investors, and other questions that you will discover during today's discussion. I hope you will enjoy today's discussion, and I would like to give a floor to my colleague Fahira to announce the launch of the first diversity initiative in the field of international arbitration for the Western Balkans. Thank you.
Thank you very much, Armela. Good morning, everybody. It's wonderful to see so many familiar and friendly faces. After a long time, it feels much longer than 2 years online. Like Armela mentioned, we do have some very exciting announcements to make this year that relate to all of our efforts in promoting diversity in international arbitration, and especially in the Western Balkans. Starting off, I would first like to announce officially that we have concluded a memorandum of understanding with Arbitral Women. Many of you already know that is the pioneer initiative for the promotion of gender diversity and the support and empowerment of women in international arbitration. And we have had a very strong but informal collaboration in the past years. So starting this year, we are now officially joining forces to participate in each other's activities and to provide mutual support. So before we announce our own first initiative, we'll now first hear from Ms. Louise Woods, who is the president of the board of Arbitral Women. Unfortunately, she could not join us today, but we are very delighted that she has sent a very special message for all of you today. And we cannot forget also Ms. Mirez Philippe, who has been a long-standing supporter and a member of our advisory board, so we also need to mention her as well at this point. We certainly hope that Ms. Woods and Mirez will be with us on some future occasion, but it's really wonderful now to officially be able to share this news with you. And with that, we turn to our Girls Empowerment and Mentorship Program, which is the first international arbitration diversity program in this region. And in short, it will bring together experienced and respected female practitioners in Bosnia and Herzegovina and the region with students and young practitioners who need initial guidance in their first steps in international arbitration. So our mentors will be volunteering a few hours a month of their time to work and to support these young women in their journey to international arbitration. And hopefully over time we will build a robust network of female arbitration practitioners who will then continue this on by themselves. So you might have seen on the sign-in sheet that there is a column where you can also express your own willingness to participate. So you can either volunteer as a mentor or you can also apply as a beneficiary. So the list will be out during the whole panel and until lunchtime, and you can still go back and apply, or you can reach out to us during the month and we will put you together with your respective counterparts depending on your role. So I will not hold off any longer. I know you're all eager to hear the actual panels of today and the discussion. Thank you again for coming to join us today and to participate in this 8th Sarajevo Arbitration Day, and we look forward to spending this day with you. Thank you very much.
Thank you, Fahira. And now I would like to invite the panelists of the first panel and our moderator, Fahira, again, who is an expert in international arbitration, focusing on investment disputes. So I would like the panelists of the first panel to join us over the table. Thank you.
So once again, in this rotation, it's my turn to start off. Thank you very much, Armela, for the introduction. We are very honored to kick off the first panel with a very hot topic. So as you can see, we'll be talking about the ECT modernization, which is the Energy Charter Treaty, modernization, energy transition, and its implications for the Western Balkans. All of these things are very prominently in the center of attention of lawyers, but also policymakers around the world, because they will determine not only how the energy market will continue to operate, but also what kind of legal consequences it will have for the private and for the business sector. So we are honored today to be joined with such prominent experts who will share their unique insights and provide us with first-hand information about the topic. But before we introduce the stellar panelists, I would just like to give a little bit of background information about what all of this is. So the Energy Charter Treaty, as many of you know, is the largest multilateral treaty governing the energy market and the economic activities in this market itself. And since its conclusion, it has been seen as a stability factor, something that allowed the opening of the markets of Eastern Europe after the Cold War to the Western countries, facilitating the collaboration and guiding to more progress in the world. And since then, it has had 53 signatories, which is now questionable. We will hear exactly why and what's happening at this moment. But in general, it was seen as a positive treaty that gave substantive protection for investments in the energy sector, but then it also provided investors an ability to seek legal recourse through investment arbitration in case the treaty was breached. But if you only learned about the ECT in the past couple of years, especially in the past couple of months from news reports, you would hear about an obscure treaty that provides unfair advantages for foreign investors, that creates regulatory chill. It is really harmful to the climate change mitigation efforts, and so on and so forth. There is even a website dedicated to the ECT's dirty secrets. So depending on the moment when you started researching the ECT, you might have a very different idea of what it is. But in any case, both critics and advocates will say that it's very consequential, and its destiny will definitely decide the future of the energy market and also our efforts towards climate change mitigation. So on that note, today our panelists will try to help us make sense of all of this. So where is it going? Where is the energy transition going in this sense? And also, what are the implications for the Western Balkans? So today with us, we are very proud to have Mr. Ilya Mitter-Penushlisky, who is counsel for Three Crowns in Paris. He has represented clients in international arbitrations conducted under all major arbitration rules, focused on complex investment and commercial arbitrations, particularly in the energy sector. Dr. Kina Baltag, she's an associate professor in international arbitration at Stockholm University and a qualified attorney at law since 2004 with extensive practice in international commercial and investment arbitration, international dispute resolution, and private and public international law. Ms. Anna Stanic, she's an English solicitor advocate and Irish solicitor with over 25 years of experience advising states, companies, and international institutions on energy law, EU law, and international law with a specific emphasis on dispute resolution. And finally, last but not least, Mr. Philip Boras, a partner with Baker McKenzie and head of dispute resolution practice in the Vienna office. He is double qualified as an attorney in Austria and New York, representing clients in international arbitration proceedings before all major institutions and also in ad hoc arbitrations. This was only in order of their presentations, so no special preference or treatment. We are very delighted to have all of our panelists with us here today. But we would start the conversation by giving more background about how we got in this situation in the first place. So I would kindly ask Mr. Ilya to explain to us what is the source of the backlash against the Energy Charter Treaty? Was it the disputes? Was it some political issues? And if there were some particular disputes that led to this kind of reaction, we'll be very happy to hear from you, from your experience.
Thank you. Dobar dan. I'm very excited to be here today among this impressive roster of speakers, and also because of the topic, but also because it's the first time I'm in Sarajevo. And I always get a warm feeling when I visit this part of the world, and when I travel to ex-Yugoslavia, the country I was born in. Thank you to Fahira and to Armela and to ARBITRI and to Giz for the invitation. Now, stepping back from nostalgia and getting to literal warm feelings, energy. It falls upon me today to set the scene for today's discussion, especially for the first panel, but I hope also for the subsequent ones, and how we arrived at a moment that's been labeled by some as the slow and painful death of the Energy Charter Treaty. If Fahira gave you a presentation of the ECT, if you will indulge me a few more words about this treaty, once hailed as the most important multilateral instrument in energy cooperation. It's a well-known story of optimism that arose from the rubbles of communism. And it was conceived by the Dutch Prime Minister Ruud Lubbers as an idea trying to single-handedly resolve the principal energy concerns of the East and the West. And those were, in short, the so-called West needed security of supply, the so-called East required capital and know-how to refurbish and jumpstart energy production units that were failing. The West worried about investing in the East where judicial protection, where functioning judiciary and protection of property were largely aspirational. And the East was concerned that it would not be able to materialize these aspirations into true reform in time to attract capital. So the solution was the ECT. It took nearly 4 years to negotiate. When I worked on the UCOS arbitrations, I scoured through the travaux préparatoires of the ECT in the vaults of the Energy Secretariat in Brussels. And it was fascinating to see how the sausage was made by experts and diplomats. Now back to the story. By any measure, the result of the negotiations was a real success. A promise of energy cooperation in Europe and beyond. A treaty that regulated energy, investment, trade, transit, and efficiency. A treaty that applied to the economic activities in the energy sector, something that was broadly defined to include most energy carriers of that day, including electricity produced from renewable sources. Now, the ECT has had 53, I believe, signatories. Some, notably Russia, did not ratify it, but applied it provisionally until 2009 when it decided to not become a party of the ECT. But it was not just Europe and Russia that signed up to this treaty. Central Asia and Japan also were signatories. So that's in 1994. Today, as Fahira mentioned, we seem to be at the beginning of an exodus from the ECT. This year, well, Italy left the ECT in 2016, and this year 6 other countries have announced their departure from the ECT. This includes the original champion of the ECT, the Netherlands. The vote on the proposed modernization of the ECT, which was supposed to take place yesterday, was postponed until next year, but perhaps indefinitely. At the screen, I have set out a timeline that shows one more. There you go. That shows the beginnings. And if you click further, can I control that or no? Can I control, do you have a clicker?
There.
No? Okay, that's fine. Okay, that's okay. And you can see the beginning and the present. So, signed in 94, preceded by the European Energy Charter in 91, and you have in 2016 and 2022 the exit of 7 states. What happened in the meantime and why are states leaving? Well, the first thing to observe is perhaps something that's quite obvious, and that is the number of cases that we've seen over the years. And as you can see on the slide, I've overlaid on the timeline the number of cases since 2000 and onwards. Most of these were commenced in the early 2010s, mid-2010s, and with the average duration of an investment arbitration of 4 years, most of them yielded results towards the end of the last decade. So these 150 ECT cases gave plenty of material for states to react to the ECT, but also for observers to hatch theories about the ECT and what's wrong with it and what's not wrong with it. I have selected what I think are 4 clusters of ECT-related cases that I believe are very important for our understanding of what affected the political position regarding the ECT. So, to begin with, in chronological order, beginning in 2007, Hungary was the respondent in 3 arbitrations launched by European investors concerning the termination of long-term power purchase agreements. Now, in the arbitrations, Hungary was claiming that what it was doing, the termination of the PPAs, was based on its efforts to implement European law in respect of state aid. The European Commission intervened as an amicus in all 3 cases. Hungary won 2 of those and lost 1. And a side marketing point, I was involved in the team that helped the one investor prevail. But the point is this: through these cases, the European Commission learned that an investment tribunal can examine EU law, including competition and state aid law, and that a state may be found liable even if it argues that what it was doing is complying with EU law. And this matters became worse at the time when the Mikula arbitration was commenced, and as we all know, that is not an ECT case, but it was, it further inflamed the European Commission in its crusade against investment arbitration. That led to ACMEA and the termination of intra-EU bids. Now, the second chronologically important matter is Vattenfall suing Germany for the phasing of nuclear power. In 2011, Germany, which we all know is a significant capital exporter, found itself as a respondent in an arbitration because of this phase-out of nuclear power generation. Vattenfall, which is also a European-Swedish company, argued that the shutdown infringed upon its rights under international law and sought compensation from the ECT. And so Germany, its politicians, and the NGO sector were in uproar because, as everyone was saying, Germany was pursuing public policies that were the result of the fallout from Fukushima, and that it was strange that a private tribunal could sit in judgment of such policies. Now, this comment ignores one important thing, which is that the Constitutional Court of Germany itself twice held that insofar as the amendment of the law on nuclear power did not provide for compensation to nuclear operators, then this was contrary to German constitutional law. A third group of matters, and perhaps the most influential ones, are the flurry of arbitrations against Spain and Italy, a total of 64 cases today and counting, in respect of modifications of legislation regarding electricity produced by solar panels. The investors argued that the 2 states lured their investments through promises about feed-in tariffs regarding renewable production of electricity, but then but then went on to modify or even entirely withdraw those promises. Many arbitral tribunals agreed with the investors and ordered Spain and Italy to pay substantial damages to green investors. Fourth, and this is very recent, Uniper and RWE, German companies, launched two arbitrations against the Netherlands for the Dutch government's efforts to phase out coal. Now, it seems pretty egregious for investors to be suing a government for phasing out coal in current circumstances, but I think that the situation is far more nuanced if one looks at when these investments were made and on what kind of encouragement from the Dutch government they were made. In fact, these plants came on stream very recently. So their lifetime is only at the beginning, and one could argue that the investment that was made that was substantial had not been recouped at all. Fourth, and so against that background, in 2006, you have these four sets of cases that all involve very sensitive issues: intra-EU disputes, public policies seeking to phase out certain types of electricity, policies regarding the attraction of renewable energy. Against this background, in 2017, the member states of the Energy Charter commenced a modernization process that involved 16 rounds of negotiations and produced a draft treaty that was draft amendments of the treaty that was leaked in June 2022. And one of the key discussions that was had between the parties was to phase out fossil fuel protection in the ECT. And the draft treaty that was leaked in June well envisaged phasing out of fossil fuel protection, excuse me. Now, last month, if we go to the next slide, last month, the European Commission itself hailed that draft as being consistent with the Paris Agreement's objectives, and that you have on the slide, and it's from 5th October 2022. Now, the vote on the ECT, as I mentioned, was supposed to take place yesterday. It didn't take place. Many states left the ECT in the meantime, since June, and these are the statements, the ones that you see on the screen, that I've been able to collate from the states, and they've offered explanations as to why they're leaving the ECT. And they fall broadly in two categories, if you'll permit me. One is that the ECT threatens the EU legal order, and the second is that the ECT is incompatible with the Paris Agreement and the fight for climate change. One wonders if matters are as simple as they are stated in these statements. My personal and humble assessment of the drivers behind what is happening is as follows. First, nobody likes being taken to court. The ECT has produced 150 cases, and although today the East-West dichotomy might no longer be as pertinent as in 1991, the so-called West is now facing just as many arbitrations as the so-called East, if not more. Perhaps avoiding arbitration is more important than having one's investors enjoy investment protection. Second, it is true that the European Commission does perceive investment arbitration as a threat to its supremacy in the European legal space. It has acted ferociously and effectively, and it has gotten states on that bandwagon. Third, and this is perhaps a side comment that I'm less qualified to make, but I'll venture and say that there appears to be a general retreat from the paradigms of Bretton Woods and the Washington Consensus that cross-border investment flows should be encouraged and protected, this seems to go hand in hand with the reactions to globalization. Fourth, and I suppose this is my key point and last point, the backlash against the ECT, to me, is prioritizing immediate publicity gains over real substantive advancement in both investment protection and pursuing the Paris Agreement objectives. Sure, leaving the so-called fossil fuel treaty is low-hanging fruit when it comes to marketing one's efforts to fight climate change. But here is the simple reality. First, and as you'll see in the last slide, and I assume most people know this already, the vast majority of cases under the ECT are renewables cases. They're not fossil fuel cases. And as I mentioned, the second point is that the modernized ECT envisaged phase out of fossil fuel protection. But, as I'm sure many of us here know, nicknames tend to stick. And the nickname of the ECT as a fossil fuel treaty has stuck. I don't believe it's crazy to say that the war on global warming is better served if a treaty encouraged investments in renewables and phased out coverage of fossil fuel investment, than if a treaty no longer protects any kind of investment, including investment in green energy. And lastly, I think the paradox of all of this is as follows. Under the ECT, under Article 47, if you exit the ECT, you are obliged to provide protection to existing investments for another 20 years. This includes protection to fossil fuel investments as well. But if you modernize the treaty and agree to an early phase out of fossil fuel protection, you might be able to establish earlier end of fossil fuel protection under DCT. Thank you very much.
Thank you very much, Ilya, for this very important context. And the reason why we needed this history is just to explain that you need to read beyond the headlines, and it's much more nuanced than it might appear at first glance, because obviously there have been serious efforts over 5 years of discussions to modernize the treaty, to talk about ways to bring it closer to the goals of the Paris Agreement. But definitely these are things that cannot be done overnight. However, as we just heard, after this revision process, after the text was proposed to the member states, they have decided not to vote. They have postponed it. So apparently they are not satisfied with the outcome of the reform process for now, and we will yet see how it ends up. But still, it's very important to linger for a moment and to see what was put on the table, what were the comments and the reactions of the member states, and then, if possible, to comment on what are these reactions and what do you think they're based on. So, Krina, it would be wonderful to hear from you and your perspective. How do you see the whole reform process and its aftermath?
Thank you very much, Fahira, and thank you, Ilya, for setting the scene. I just wanted to add to the interesting statistics at the end. The last slide is the outcome of this arbitrations under the Energy Charter Treaty. Because it's one thing to be taken to the court, and the other thing is the outcome of that arbitration. And the statistics show that in most of the cases, the respondent contracting party to the Energy Charter Treaty will prevail. In 28% of these cases, tribunals found that there was no breach of the Energy Charter Treaty. 13% there was no jurisdiction of the arbitral tribunal, and in 4%, although there was a breach, there was no damage. So we have split 45 to 45% between investors and contracting parties. And I think this outcome shows that to a great extent, arbitral tribunals manage to understand, interpret, and apply the Energy Charter Treaty in the context of the specific circumstances of each case. But going back to the modernization process, as it was said when officially has started in 2017, there was, in Astana, there was an approval of the issues to be dealt with by the Energy Charter Modernization Group. So already beforehand, those provisions in the Energy Charter Treaty have been identified, and the work was focused on those provisions and new provisions to be included in the new Energy Charter Treaty. As some of you may know, and as Ilya mentioned, the Energy Charter Treaty is not only about investments and arbitration. There are other very useful provisions, including the provisions on the environmental issues, which was in a minority of cases referred to by arbitral tribunals. We had the transit provisions proved to be effective in the numerous gas transit disputes between Ukraine and Russia. We also had the trade provisions we have in the Energy Charter Treaty, which help the non-WTO countries, contracting parties to the Energy Charter Treaty, to accede to the WTO, to face this accession process easily. So I think we have to keep in mind that there are many still useful elements in the Energy Charter Treaty. Now, how the modernization process was dealt with behind closed doors, as we are today, there was no transparency except for the few statements or general statements made by the modernization group, effectively led by Lukas Stifter, who was the representative of Austria in the Energy Charter Treaty and the head of the modernization group. But again, no transparency of the process, and that, from what I understand, was meant to be a form of effectively and efficiently achieving an outcome in a short period of time. If you open the doors and you let us in, us, the public, you'll probably not have an outcome in such a short period of time. So the agreement in principle on the Energy Charter Treaty was in June this year. From my knowledge, there were two free draft papers, draft modernized Energy Charter Treaty leaked to the public. So we do have some information, at least on the preliminary text that was put forward to the contracting parties. When it comes to the outcome, before I go a bit in the proposed changes to the treaty, when it comes to the outcome, the Energy Charter Treaty is very peculiar. Some of you know that we have the treaty, we have the Secretariat of the Energy Charter Treaty, we have the depository contracting party, which is Portugal. But on top of that, the Energy Charter Treaty is part of a series of elements which were set up in 1991 and continue in 1994 with the signing of the Energy Charter Treaty, 1998 in force, and then we had the modernization of the Energy Charter, European Energy Charter, which was the basis, the commencement of the Energy Charter Treaty, and that modernization process of the European Charter converted it into an international energy charter in recent years. And all these elements taken together, they are supervised by the Charter Conference, which includes, obviously, the contracting parties to the Energy Charter Treaty, and of course, there are observer states which are signatories to the International Energy Charter. So a very, I would say, complex framework in which the Energy Charter Treaty activates. So in order to get to the approval by the contracting parties of the amended Energy Charter Treaty, that has to be put into discussion in the Energy Charter Conference. And this is what we had yesterday, the Energy Charter Conference meeting, where the amended text of the Energy Charter Treaty was supposed to be approved by all the members of the Charter Conference, all of them, so unanimity. And then once approved, it could go to each contracting parties individually, and each contracting party would decide whether to approve it or reject it. The Energy Charter Treaty modernized form would have entered into force if approved by 3/4 of the contracting parties. So there are 2 stages of the process. And this is why the European Union, given the internal vote on Friday last week, decided to remove the modernized treaty from the agenda of the Charter Conference, because there was no way it could get the unanimous vote to proceed with the second stage. So this is why perhaps in April next year we'll have this. Now, moving to the provisions, there are obviously many amendments, but I would put them in 3 categories. The first category deals with, as Ilya was mentioning, the transition to clean energy, complying with the commitments under the international instruments, including the Paris Agreement. And the reality, as you could see, is that the Energy Charter Treaty equally protects renewable, clean energy and fossil fuel energy. The idea was to remove the protections of the fossil fuel energy in order to have this transition to the clean energy. If contracting parties are hit every day with claims from investors in the fossil fuel industry, it will be impossible to focus on the end goal, which is to meet the targets of the Paris Agreement. How was that proposed to be done? 2 streams. The first one, and I think the third panel today will cover this, including sustainable development provisions in the Energy Charter Treaty, which was the old provision on environment, now well expanded and with ample reference to the international commitments of each contracting party, and the provision on climate change, which is very important for the Energy Charter Treaty. There is a proposal to have a specific provision on climate change and energy. The second stream concerning this transition to the clean energy was to amend the definition of economic activity in the energy sector, which is the core, let's say, notion of the Energy Charter Treaty. And that was done by way, very interesting, by way of annex to the treaty, meaning that for the existing investments in the fossil fuel industry, there is a gradual phase out of 10 years, as Ilya mentioned, with some exception until 2040 extended protection for certain types of energy materials and products, for example, pipelines that can be used for the transportation of clean energy and so on. And for investment made after 15th of August 2023, no protection in this context. So obviously a better deal than the 20-year sunset clause that was mentioned earlier. So 2 ways of achieving this goal, in my opinion, probably effective if one can think about it. The second category of provisions reflect the experience of the contracting parties in this 150 cases. And I'm not sure if that's the right approach when you draft an international treaty. A treaty has to be approached to last over time and to be adaptable to the new realities. The proposals was effectively to address the concerns in these cases. For example, the definition of investment. In the modernized treaty, it was introduced the so-called Salini test with all the additional criteria for the investment, definition of investor with the requirement of investor having a substantial business activity in the country of incorporation, so effectively addressing the concerns of shell companies, those incorporated in fiscal paradises and treaty shopping. And of course, on the standards of protections, fair and equitable treatment, most of the Spanish renewable cases where tribunals took different approaches on the fair and equitable treatment, the legitimate expectations of investors, concerns with third-party funding, with frivolous claims, with evaluation of damages and so on. There are, I would say, complex proposals of modification of these provisions. And last category, and I'm sure we can discuss more about each individually, the last category of modification or amendments is effectively allowing, in the context also of the transition to the clean energy, allowing the contracting parties to deal with changes in their regulatory framework without being punished for doing so, including the implementing measures effectively, for example, encouraging renewable energy or dealing with the phase out of fossil fuel. And that is the sovereign right to regulate of a state, which in the modernized treaty is recognized in a specific provision. Also establishing an additional category of exceptions from the treaty, for example, in case of war, which is relevant in our context nowadays. And the last one concerning expropriation. So there is a lot to put there, and I would say on overall, the suggested amendments could have been useful for the contracting parties. Thank you.
Thank you very much, Krina. The reason why it's very important also to hear about these proposals, although they have not been yet voted on officially, is because we can see, even though there has been progress and movement towards exactly what the states were asking for, so there is it has addressed the fossil fuels, it has addressed the definition of investor and investment in the way that the EU and its member states have stated. Still, there's even a dichotomy of approaches between the EU itself and its member states who are claiming that it's still not enough for the Paris goals. So we will see definitely now what happens, hopefully in April. They don't make us wait any longer, but it's something to watch in the future. And now it's a good moment to turn a little bit away from the ECT in the narrow sense and to see what other tools and mechanisms have been used in the legal framework to address the energy transition concerns and problems. And there has been a wave of claims, mostly in national courts, against both public and private entities for either acts or omissions that seem to harm the energy transition efforts or do not promote them sufficiently. So this is something that is called climate change litigation. So Anna, it would be wonderful to hear a little bit more about what kinds of claims are these, what is their nature and effect, and also do you think this might be a more used and more useful tool in the energy transition process itself?
Hvala Fahira, dobar dan. I'm pleased to also be in Sarajevo, although I can't even remember how many times I've been here, but I'm very happy always to be here, and I'm hoping I'll take Ilya tomorrow morning to my favorite Sach to have pita. So, basically what we thought is at this point when we've heard sort of the broader context of, let me say, investment disputes in terms of, and when Philip will talk about it really in terms of the energy transition, is really to give you some context in terms of other types of claims that have been brought in national courts or the European Court or in the European Court of Human Rights as mechanisms to address climate change. So I would emphasize that these are claims against climate change rather than energy transition types claims that we'll talk about later in the discussion, in the sense that energy transition claims are really claims that we're talking about investors bringing against states, whereas when we talk about climate change, we're really talking about actions taken, as Fahira said, against private companies or states for failing to take actions to address climate change issues. And here I will give you really, I'll concentrate primarily on the European Union, because there are cases all around the world, except for, I will mention briefly the US, and obviously the most famous case of the Peruvian farmer that brought the case against RWE, that I think is sort of a key kind of claim to understand. So perhaps start with the Urgenda case. Urgenda case is a case that was brought back in 2015 in the Netherlands by a number of individuals who argued that the Dutch government or the Dutch state had a legal duty pursuant to Dutch law and also the Article 8 of the European Convention on Human Rights to take more measures than it had in terms of addressing climate change. So it basically said that the obligations that the Dutch government had pursuant to EU law were not sufficient in order to address its obligations under the Paris Agreement, and that the obligation needed to be taken further. That case ended up all the way in the Supreme Court, and in December 2019, the Supreme Court held, after it being confirmed at the appeals level, also that the Dutch state had an obligation, and that obligation was beyond the law that was imposed, and that in fact they needed to reduce their carbon emission by 25% by 2030. And that immediate measures needed to be taken in order to achieve this. That led to immediate actions from the Dutch state, which included things like reducing the speed limit on highways and so on and so forth. And now, as you might know and you might have followed, there is attempts to obviously address the issue of methane emissions by cows, which seems slightly ironic given the methane emissions that are caused by other things, including gas production. But anyway, that's where we are. So the impacts potentially are unexpected in the terms that the farmers are now up in arms, and the Dutch government is basically being stopped quite successfully by the Dutch farmers in their activities. But that's a very good example of how, in a very innovative way, arguments on climate change were put forward and successfully argued in the Dutch courts. The same arguments are now being used around the world to raise the same issues. The Peruvian case is a case that started again in 2015 by a Peruvian farmer called Saul Luciano Lluya, who lives in a village called Juarez in Peru. And as a result of climate change, he has argued that the lake has been growing in size above his village as the glacier has been melting, and that it has, and it is the claim, it has a serious and immediate risk to the inundation and the flooding of his village and the disappearance of his village. And he has argued and brought a claim in German courts, not in Peru, but in Germany, against RWE, one of the biggest utilities in the world, arguing that its contribution to CO2 emissions since 1970s, and if not before, have contributed to the global warming, and indirectly or directly, in fact, to the melting of the glacier above his village and the creation of the lake, and has calculated that contribution amounts to 0.47% of the total emissions in the world that RWE is responsible for. Initially, this friend of mine who's arguing the case, Rada, was told that there was no chance that she would have any success for this case. The case has been argued on the basis of a duty of care, linked again to the Article 8 of the ECHR, the European Convention on Human Rights, as a basis for a claim in Germany by a Peruvian national. The case, after being dismissed initially, has now been rejuvenated, I guess. It started again. It's been sent back to the original court. And the court has, in May of this year, sent experts, and the judge have gone to Peru to actually look at the damage and assess the causality issue. So the case is being, at the very least, seriously considered by the German courts. So that's where that case is. Another interesting case that is in the appeal stage in the European Court of Justice, or the Court of Justice of the European Union, is called the People's Climate Case. It was started in 2018, and it has argued, and this is a claim against the European Union, as opposed to member states of the EU. It's brought under the EU treaties, and it seeks to nullify and also bring a claim for non-contractual damages claim against the EU for failing to adopt sufficiently ambitious regulations and directives in terms of renewables targets and also in terms of CO2 emissions. This claim was initially dismissed by the General Chambers of the European Court, the CJEU, the Court of Justice of the European Union. It's now on appeal. It's been on appeal for, well, since 2019. I guess Corona has been keeping them busy with other cases, as has the war in the Ukraine. The key reason for the dismissal of the case is a very contentious issue generally in EU law, and that is the lack of standing that individuals have under EU law to challenge decisions of whether it's in legislation of the European Union. If there's anything to go by, the expectations are that, at least my view is that it's likely that the appeals court will give standing. And the reason for saying that is that in a recent decision with respect to Nord Stream 2, the standing position of the court has been clarified, and it is confirmed a slightly broader definition of standing than we've had so far. And I would imagine that if the court was prepared to do it in the Nord Stream case, that it is very likely to do it with respect to a climate change case, because I think the uproar will be enormous if they were to find that individuals had no standing to challenge climate change policies on the basis that, as the General Court said, that if all people are affected by something, then there's no standing, which seems like a strange definition of standing, at least from a national point of view. Briefly to talk, as Fahira has mentioned, there are also claims not only against states, but also against private companies. And these claims, I'll just give you some because there's numerous examples. One that has been extremely successful was a claim brought by Client Earth. First of all, Client Earth in Poland became a shareholder in one of the companies that was publicly listed that was investing in the construction of a coal power station in Poland. And then based on that, it then sought to challenge the decision of the company to go ahead and build a coal power station on the argument that it was actually exposing the shareholders to unforeseeable risk, because constructing, they argued, a coal plant when it's likely that that coal plant will be shut down in the future as a result of its contribution to CO2 emissions was going to then present the shareholders with a situation where they would never recover their investment. That claim was successful, even though it was in the Polish courts, which you would have expected maybe that they wouldn't support such an action. The project is going ahead, but no longer as a coal power station, but as a gas power station. I'll just put a little note here that we maybe will discuss later, or there might be questions in the audience. The whole situation with coal now, since the war in Ukraine and the sanctions imposed on Russia, has changed. So coal is no longer the bête noire. In fact, it's now seen as the savior of the European Union, so we'll see how this pans out, and this is something that will then be in discussion with terms of energy transition disputes going forward. And maybe just finally, two types of claims that are perhaps interesting is the claim against Shell that was brought in the Dutch courts on the back of Urgenda, but this time, obviously against Shell as a company. And this is an argument that we are now in the court has now accepted that it has jurisdiction. And basically the argument is that Shell has violated its duty of care as a company in conjunction when that duty of care is read again with Article 8 of the European Convention of Human Rights for its contribution to emissions of CO2, not just in Holland, but throughout the world. So for all of its subsidiaries. So the if the claim is successful, it will actually be assessing Shell's contribution worldwide to CO2 emissions and the potential damages for that. So it's a very important claim. And in the United States, there's very many claims, not least against ExxonMobil, for both, I would say, forward-looking knowledge in terms of not forecasting correctly the cost of carbon when they approve projects. That claim so far has been rejected, but I'm sure it will be rejigged and brought in another way. And then also other claims, for example, in the courts of Massachusetts, which are claimed for its past knowledge of climate change, because what has been discovered in discovery is that ExxonMobil directors were discussing climate change and the risks of CO2 emissions already back in the 1970s board meetings. And the argument that has been put by the state advocate generals in the United States is that that knowledge was hid from the investors, and that therefore is a breach of their duty. Whether in some states of the United States it's argued under the Securities and Exchange Commission rules, as opposed to the duty to disclose to the stock exchange, because it's a listed company, and in other circumstances under other provisions of the law. So I think this gives you some sense of the numerous types of ways in which claims with respect to climate change have been brought using different tools, very inventive tools, to both hold states and companies accountable. And I'll stop there.
Thank you very much, Anna. It's fascinating to hear, and we definitely could have dedicated a whole day just to analyzing all of these various cases, because the public and private perspective just shows you the amount of pressure that's on states to not only follow and regulate and protect investors and keep the economy going and the energy sector going, meeting the climate change goals, so many moving factors at the same time, while also facing backlash from the private and from individuals who are citizens in the country. So just another layer of nuance to the discussion that we have had. So we have heard many risks, policy risks, litigation risks. We have heard about many types of exposure that states and companies can have. We would like to end at least the formal panel discussion on a very positive note, because on the other side of this coin of the challenges of climate change and changing the energy policies, there's also a lot of opportunity. So there are some estimates that there is an investment gap between 120 to 450 billion in renewable energy investments that are needed and sought around the world that will also definitely require some security. But for a region like the Western Balkans that is rich but also in transition and moving towards the EU and some bigger ambitions, this period of uncertainty might also create opportunities both for the states and the private sector. So Philip, we'll now let you encourage us and share some of these opportunities with us.
Thank you very much, Fahira, and thanks again also for inviting me to all members of the Association ARBITRI. I'm very happy to be here again in Sarajevo. So I was asked to end on a regional perspective and on a positive note. The first I can do, on the second, a positive note, I'm not so sure, but let's see where it gets us. Why I'm not so sure is that, of course, these opportunities are not gonna come by themselves. We need to do something so that the opportunities really come to the Western Balkans. And what is positive about it, that we can change it. We can create a field, a market in the Western Balkans that will attract those investment opportunities. Compared to now things like the Energy Charter Treaty and the future of it, which I believe we cannot change so much, because once the European Union has decided to do something, they usually do it. So I'm not sure but what we can change is we can change the environment in the Western Balkans. Currently, we are not in a very good starting spot. 83% of the available energy in the Western Balkans comes from fossil fuels, compared to around 70% in the European Union. But still, there are significant opportunities, not only to attract investment, but also by doing so, by moving faster in decarbonizing the economy, we can also move closer to the European Union, and we can play a greater role in this Eurocentric chain of values, which potentially could also speed up the entire accession process. And yes, I said we're not in a very good starting point as the EU maybe, but we are not that far away, because also the EU member states are in a very, very initial phase of the energy transition. So we can catch up here maybe faster than in other fields. And I believe that the big opportunity is not only that we can gain access to a significant volume of the EU resources that you mentioned that are available to fund the energy transition, but I believe that the Western Balkans have great potential for the production of some of the green technologies and some of the products which will come along. And let me just give you one example. And we're talking a lot about electricity, generation of electricity, renewables. Yes, there are projects going on for solar power plants, for wind. Yes, but that's only one part. This is generation of electricity. But the heavy industry will, of course, need a replacement for gas at some point. And this is where the EU looks into hydrogen as the future fuel for the heavy industry, and especially for industries like steel, cement, glass, aluminium. All this will need some replacement for gas. And I think just this year, the European Commission has announced a 3 billion package, which they call the Hydrogen Bank, to fund the development of green hydrogen. Of course, we know hydrogen for a long time already, but it's dirty hydrogen. But we're, of course, here speaking about green hydrogen. And this is only the Commission's funds, but when we look into other state aid that is available for hydrogen projects, I think there is more than 13 billion of state aid approvals only in Europe to perfect the hydrogen technology and to ramp it up to industrial production. And not only, when we look into projects in Germany, in Spain, but also in Romania, there is currently 194 million subsidy for a project of a Romanian plant for the production of hydrogen. And the goal of the European Union is, of course, to boost the hydrogen share to 14% of the EU's final energy demand by 2050. And if this should be happening, the hydrogen that the EU needs will not be produced in the EU. It needs to be produced somewhere else. And to produce green hydrogen, you of course need to produce green power, so you could produce the green hydrogen. And of course, the European Union is mostly looking into North Africa for the production of hydrogen, just for practical purposes, because there is more sun. Solar power is the cheapest way to generate power for hydrogen production. And so the best is to do it in North Africa and then ship it to Europe. But how to ship it to Europe? The entire infrastructure is not yet there. So if we think from a Western Balkans perspective, in this interim way, also the Western Balkans could be an attractive place to produce green hydrogen, not only for the Western Balkans, but also for export into the European Union. This is just one example of the opportunity that we have. But I said in the beginning, this opportunity will not just come. There is a long way to go in order to make the Western Balkans an attractive place for the production of green energy. And there is one thing that is not going well so far, and that I think we can change here, and this is the implementation of a stable regulatory and market legal framework to do that. I doubt that any investor will come to the Western Balkans if his investment is uncertain and if the regulatory framework is not there. And I'm not speaking now only about investment protection, but actually a much further field, namely we need integrated energy markets between the countries of the energy community and the European Union, so you can export the green energy. This is something that is currently not in place. So we need to create it to allow for cross-border energy trade and a full integration with the EU market. And this is not happening because, especially when you look, for example, to Bosnia-Herzegovina, I mean, we're speaking about necessary legislation not only to implement the third EU energy package, but not even the second EU energy package is fully implemented. And I, of course, understand that it's difficult with the two entities, but most of the legislation is on entity level. And I think the federation is even worse off than the Republika Srpska. And this is something that we have in hands. I mean, this is legislation that needs to be passed. And if we don't do this, we can forget about capturing the opportunities that are here to come. They will go somewhere else. And so my question to all lawyers, or to all local lawyers that are here today, I think we need to lobby much more to have EU legislation transposed into national legislation and to enable the market to operate in an integrated fashion. And of course, this will also lead to security of supply. I mean, that's clear, and we see it now with the Ukraine war. And you mentioned coal is now a replacement. Yes, it's there because we eventually need some energy, and if gas is not there, and renewable sources are not yet developed to a necessary extent, then of course we need to go back to coal, but that is of course not a long-term solution. And when I look to the framework, and in preparation of this panel, I went through the energy community reports, and when I looked to last year's report of the energy community of Bosnia-Herzegovina, they say in 2021, the 22 report is not out yet, but in 2021, there was no development at all in legislation for renewable energy sources. I mean, this can't be the case in the situation we are today. And quite to the contrary, the energy community has also initiated infringement proceedings against Bosnia-Herzegovina for two coal-fired power plants that Bosnia has committed to take off the grid, but has not done so. So this is, we need to move much, much faster in terms of implementation and legislation. When we come to renewables, this of course also includes transparent support schemes for the promotion of green energy, which is also not happening. There are support schemes, but they're not transparent, they're not efficient, and this is also somewhere where we need further development. And finally, of course, we need to liberalize the market. We need to get rid of the domination of the market from the incumbent players. The incumbent players do not want a liberalized market, but it needs to happen. Otherwise, there's no alternative to achieving security of supply in the Western Balkans. And I can give you, to transform this all in practice and not just to good aims, I can give you one example in a case where I do represent, where this has failed in a Western Balkan state. where there was the promise to implement the second and third energy package, which attracted investments to a gas distribution grid, but it simply never happened because the incumbent, which had a 97% share of the local supply market, simply had no interest. And the incumbents, of course, control the politics control the regulator, and so this just doesn't happen. And of course, when you have a market situation like this, you can't attract new investment. Because we are in an arbitration conference, where is the potential for the disputes lawyers here? I think you don't have to worry about this, because where there are projects and where things are happening and where investments are happening, there will inevitably also be disputes. Maybe not so much investment disputes. I don't know how this will develop and what the investment framework will be. I don't think that the Western Balkans should be the last man standing in upholding all these treaties. My advice, if the European Union is out of it, we should also be out of it. And why should we offer more protection than new member states? Someone who believes that the courts in Croatia are better than in Bosnia, I can tell opposite stories. So the idea that the justice system in the European Union is efficient and functioning is not true, even to more developed jurisdictions. So I don't think we should here be the last man standing. And if we follow the EU policies on energy transition, we should also follow them on treaty protection. That's my view. I don't think it's good, but so be it. But we shouldn't be the last man standing in upholding all this. And I'm happy to hear opposing views from my panelists. I'm sure there are some. But also here, no worries. There will be still enough opportunities in commercial arbitration. And of course, all these investments will have arbitration clauses which govern govern their dispute resolution mechanisms. And I think here it's particularly important what the association ARBITRI is doing, namely also to prepare the state actors, but also the private actors, to have good and solid dispute resolution mechanisms in the investment agreements, so that there is no disappointment when it comes to a dispute. I mean, a dispute is always a disappointment, but at least to have an efficient dispute resolution mechanism. And I thank the association and for all their efforts to educate the local community in drafting good and efficient arbitration clauses. Thank you very much.
Thank you very much, Philip. So we are now left with a lot to discuss and 5 minutes left on our time. So we will open the floor if there are any questions, but in case there's some comments from the panel also on the input from each other, we can maybe do a round of such comments first, and then the questions. And don't forget, our panelists will be with us all day, so breaks and lunches and all other opportunities, you should use them to approach them to discuss issues you might not be able to raise here. So is anybody interested first? Karina?
Very interesting that we all mentioned the amount of investments required for the transition to a clean energy, and in particular the consequences the companies will have from having to comply with the court decisions. And let's not forget the fact that this summer the United Nations recognized formally that the right to a clean energy is a fundamental right. And this will have massive consequences on all the treaties from now on, because they will have to comply with this. But I think it's very interesting to put the numbers here in place. And Ilya was mentioning in the range of 260 billion per year only in the European Union. At the level of the entire world, the estimate is 131 trillion per year. And just to put this in perspective, our discussion today was one, transition to the clean energy and complying with the obligations under international treaties and the Paris Agreement. The second one is as a consequence of this, the phase out of the fossil fuel. And I think the third one, it goes to what Philip was mentioning. We have to look at the realities of each country and understand that the first two have to go hand in hand with providing the alternative technology for the major users to be able to transition to the clean energy. If there are no means to do that, if the investments are not there, then the first two will never work well in this context. And at the same time, also from what we discussed today, is those funds are coming, those billions and trillions are coming from the existing energy companies who will have to reassess their priorities for the future. So I think the states have to evaluate their next steps carefully.
Thank you very much, Kina.
Maybe just to play the devil's advocate, given Philip's position, I would not recommend to Bosnia to pull out of the ECT for one reason that Ilya and Karina mentioned, that the actual sunset clause in any event extends for 20 years. So the reality is that the protection is going to be there. I don't think we should follow the position of the EU. I think what Bosnia needs to do is to be very careful on how it drafts laws and regulations in order to, and the kind of promises and legitimate expectations it creates, because I do think it needs to attract investment. So I think in this respect we should follow the United Kingdom and America and all the rest that are not proposing, like NAFTA is not proposing to disappear. So, but I would say one other thing that I think is actually more important than that in terms of the broader energy transition, and this is the complexity in which Bosnia finds itself in particular in terms of the pressure that it finds itself in to develop hydropower as a so-called renewable energy. However, it needs to bear in mind that actually the obligation, which already now exists under EU law, to rewild rivers, which will become a much more concrete obligation in a very short period of time, I would suspect, will be something that will then affect the very hydropower projects that it's now being asked to develop. And this period of time between when it develops the new hydropower project and the rewilding will not be driven by Bosnia's interests and needs, but will be driven by the pace in the EU, which will have nothing to do with the interests of Bosnia, because it can't. And so I think the position, and this is where I think COP27 was very important in this position, and the position of African countries in terms of their right to use fossil fuels for an extended period of time, is I think where Bosnia needs to find its supporters and its position, rather than in the EU, which is a much more developed market and has other priorities. And so I would suggest that that's the way forward for Bosnia to find its position, otherwise it simply will be not competitive in any shape or form, and the introduction of carbon adjustment mechanism may well hit Bosnia very hard in terms of its ability to continue to export in the EU, and this is another thing that Bosnia needs to take care of in order to ensure energy transition of its industry and so on.
One question for you. I mean, is you mentioned the sunset provisions. I mean, I don't want to open the Pandora's box of discussion, but would this also be the case if the sunset provisions themselves are terminated?
I won't go into that Pandora's box, but I would, because I think it's too difficult to answer that now. But I would still say that yes.
I think there are differing views on that, but I wanted to react to something that you said earlier, which was, it concerns the following the herd mentality and the suggestion that going against the EU perhaps might not yield the best results. And the practical example I have is having represented Lithuania for about 8 years in 4 mega arbitrations, 2 against Gazprom, 2 against Veolia, is this. If the Baltics were 100% dependent on gas from Gazprom. Gazprom also had a significant stake in the three main companies in the Baltics. And of course, the EU was saying, well, you have to pursue the third energy package. You need to unbundle Gazprom's control on the network, and you need to, in that way, free yourselves of the shackles that you are currently facing. Now, Lithuania did that, as did the other Baltic countries. And of course, Gazprom sued Lithuania for forcing it to divest its transmission network assets. But the point was more fundamental in the following sense. There was a certain minister of energy who claimed, look, we'll do that. That's fine. But what we need is diversity of supply. And just by unbundling the networks from supply, it's not going to be sufficient for us to get ahead. And against, at the time, at the beginning, against the EU's advice, he pushed for the creation, as we know, of a LNG regasification terminal in Klaipėda in Lithuania. And there were economic suggestions that perhaps it wasn't the best location, that it wasn't perhaps in light of other plans and other LNG terminals that had to be built, that there wasn't enough demand for this particular terminal. Nevertheless, Lithuania persevered in this policy, and they are 100% free of Gazprom today. They have full energy security of supply. Thank you.
I think that's a very good example. I mean, we have two states also in the Western Balkans which are still dependent on Russian gas, Serbia and Moldova, and you know, who face a difficult situation. Serbia not so much because they're Russia's friends still, but also, you know, they might face difficulties in the future. And I agree that unbundling is not enough, and you know, other steps need to be taken there. But creating a stable legal framework and connecting to the European market and fully integrated, and also not only to the European market, but also within the region, is, I think, a major step to achieve this, because of course most of the countries are landlocked, so you cannot build an LNG terminal, unfortunately. But I think the more flexible we get, the more we can import alternative sources from other countries and within the region and outside the region, the quicker it will go. I'm convinced of that.
Thank you very much for all your input. I mean, we got additional food for thought even in this short discussion. I wish there was more time. We have two fantastic panels that are still waiting for us, and also a coffee break that I know you are very excited for. So at this point, I will close this formal conversation in this panel, but we definitely encourage these conversations to continue. Thank you once again for all your tremendous effort and input that you have prepared for this. You have put a very difficult and multi-layered topic into a very understandable and contextualized form, which in a country like Bosnia and Herzegovina, which is complex itself, is a very valuable input. So we are very thankful, and we value your time. Thank you again. We'll take a very short coffee break, and we will be back for panel 2. We hope you had a chance to enjoy a nice coffee break. The lunch is coming up soon enough, and we'll have a full hour and a half to continue the discussions. But we should definitely proceed now with the substantive conversations dedicated to the very important topics of ESG and energy and construction disputes. So after a broader policy perspective, after the bigger picture, now we will narrow it down to what some of you might be experiencing in your daily work and the kinds of disputes that you are facing in this area. And I will happily hand off to my colleague Armila Ramic, attorney at law at Ramic Law and the president of Association ARBITRI, who will guide us through this panel and this very interesting discussion. So Armila, the floor is yours.
Thank you, Fahira, for a kind introduction. I want to welcome you all to the second panel,
ESG in energy and construction disputes. The COVID-19 pandemic has brought ESG issues into the sharp focus for companies. The environment, human rights, health and safety, taxation, data protection, and corruption are likely to be some of the major ESG themes in coming years. ESG issues are already familiar in the investment arbitration context, where disputes concerning the energy transition and human rights frequently arise. ESG-related disputes will also increasingly arise in commercial arbitration context, as companies adapt their businesses to comply with the new law and regulations and to respond to the commercial pressures. I would like to introduce you to my panelists today, Ms. Afef Ben-Matsoub. She practices as a lawyer in Paris. She advises and represents her clients in international commercial and investment arbitration. Mr. Jovan Nikčević, who specializes in construction and energy law, with a particular focus on FIDIC-based projects and dispute resolution through arbitration proceedings, and Mr. Florian Haugeneder. He is a co-founding partner at Knotel and has 20 years of extensive experience as a counsel and arbitrator under the rules of major arbitral institutions. Well, in that regard, Florian, I would like to ask you the first question. So, what ESG concerns are particularly likely to arise during the construction and energy projects, and can you explain to us why the energy and construction sector is particularly susceptible to the ESG claims and risks?
Thank you, Amela. First of all, I would like to thank the organizers for inviting me to this conference. It really feels very good to be back in Sarajevo after some time and seeing so many good friends and colleagues. Let me start by introducing the notion of ESG, that is environmental, social, and governance principles. ESG is often used in the context of sustainable investment. So basically, ESG concerns non-financial performance criteria of companies. At its origin, this is a set of criteria used to evaluate the performance of companies in areas of environment, social responsibility, and governance. And the purpose of ESG is to support investors in making sustainable investments. So the primary context of ESG is attracting capital flows to sustainable to sustainable economy, to further transparency and to further the non-financial social performance of companies. And if you look at the various EU directives in this regard, they all focus on this notion, and the underlying idea is to create an investment framework that isn't only focusing on financial performance. Arbitration, on the other hand, and I will focus here on commercial arbitration. Investment arbitration will be discussed by other panels and panelists, is adjudicating disputes between two or more parties, usually based on contract, applicable laws, or applicable rules of laws. And as such, it's not evident that ESG are relevant or can be relevant in international arbitrations, because even if ESG principles are arguably breached, the question is, does that rise to the level of a cause of action in arbitration that is based usually on an agreement between the parties. And and of course the relevance of this, and we are discussing this in the panel is discussing in particular construction and energy, the energy sectors. If you look at the facts, 38%, I have read this morning, 38% of the greenhouse emission gases originate from the construction industry, and a very large part of the energy industry. So Those two industries are a huge part of the problem, and they also, if we want to change anything of the current situation, they also have to be part of the solution. Now, the question arises, and I think that is the kickoff to our panel: how can ESG play a role in arbitration? And if you look at this question, you will have to look at the ICC Commission report on resolving climate change-related disputes, because that's really a very thorough examination of the possible relevance of environmental, social and governance issues in international arbitration over about 50 pages. So I would really recommend to read that to everyone. Now, how can it be relevant? And the first scenario is probably the easiest one, and we all know it and probably have experience with it, is when a contract contains concrete performance criteria that are not related to any financial performance, but to environment or other human rights obligations. And that is, of course, easy, and we probably have seen that. You have, for instance, a renewable energy facility, and there are performance indicators in the contract, and the question is, well, have they been met or not? Then there is the question, was it met or not? But that basically structurally is the same thing as you would have for any other contractual performance that is specifically mentioned in the contract, and there is an argument it has not been met. The second scenario, which is already a bit trickier, is when, and that's increasingly frequent in the contract practice, at least according to what I have seen, is when you don't have any concrete performance criteria in the contract, but there is a general reference to environment, to social responsibility, human rights, etc. And then, of course, you can imagine a number of scenarios where from this general reference, a breach of contract claim or other claim can be made in arbitration. For instance, one party can say the other party has breached the contract because the environment hasn't been sufficiently protected. Let's imagine construction of a road, of a power plant, of a railway, and the contract doesn't list specific environmental criteria, but the other party says, well, according to what is the accepted standard now, your performance isn't in accordance with the contract, and can request termination, performance, or damages, for instance, to remediate environmental damages. There is also, especially in construction contracts, you could have an argument on both sides of the contractor or the investor that there is the general legal framework requires a change in performance. It requires to build additional measures to build additional measures to protect the environment, to build fish ladders in a hydropower plant, to take special measures to reduce greenhouse emissions and so forth, even though it is not mentioned specifically in the contract. And on the other hand, the contractor could argue, well, I'm obliged to add specific, to take specific measures not mentioned in the contract because I have to comply with my environmental responsibility, and I need to build this and that. And that's a variation and requires additional payments. So you can, with a little bit of creativity, you can imagine lots of scenarios where on both sides, ESG, at least indirectly, can be relevant in arbitration. And then there is the third scenario where the contract doesn't say anything, but then a party claims that the ESG principles, and the ESG doesn't come out of nowhere. It's arguably based on a body of hard and soft laws, including the Paris Agreement, human rights legislation, and domestic legislation aiming to protect the environment, human rights, and social protection. Because of that, even without a reference in the contract, the applicable law requires observance of certain ESG principles. And the choice of law clauses in arbitration are arguably allow relatively easily to make such arguments, because you don't have only the contract and the applicable law, but also most arbitration rules contain a reference to rules of law, and of course you can bring lots of soft laws, international laws, general principle of laws into the game to sustain an argument that ESG principles have to be observed by the contract partners. And what that means concretely, of course, has to be determined in the circumstances of the case. Just following up on Anna's excellent presentation, I mean, you have the famous Shell case where a Dutch district court in 2001 held that there was a concrete obligation of an individual company to curb greenhouse emissions, despite the fact that there wasn't any legislation in place that required a specific to achieve a specific target at the time. So it's possible, and I would submit quite likely, that in the next 10 years to come, we will see a lot more of these arguments made that the existing legal framework will allow to derive concrete obligations of individual companies to reduce greenhouse gases or to achieve other environmental performances, even though there is no directly applicable legislation, or at least no explicitly applicable legislation on this point. Now, and that's an open area where basically we will see how the case law and the arbitral practice will develop. My prediction is that we will see lots of more cases where this will play a role. Coming to the fourth scenario where ESG principles may play a role, and I think that's a lot more concrete, that's investor disputes based on the non-observance of ESG principles. So imagine you have an M&A transaction, and there are, of course, usually lots of reps and warranties, and in the transactions that I have seen recently, there are also reps and warranties regarding ESG principles and the observance of those principles. Imagine they have been, these reps and warranties have been included in the contract and have not been observed, as it turns out. Then this is possibly a quite straightforward cause of action for in an post M&A arbitration, and you could have two scenarios. One is basically that the non-observance as such reduces the company value, and then the target company may be faced with claims from investors or third parties, and that may have a direct impact on the company value. Suppose there is an arbitration agreement in the M&A transaction that will lead to a straightforward post-M&A arbitration. And then there is the fifth category that I could identify, which is a submission agreement after the dispute has arisen, and that is of course open to a broad area of disputes, including mass claims against big companies, and there is the question, and I would submit arbitration is at least in the transborder issues and more global claims perfectly suited to administrate such claims, including mass claims. Now, let me conclude this kickoff by mentioning why I would submit that arbitration is well suited to adjudicate these claims, and I would also submit, given the importance of the topic and the very likely dramatic increase of such litigations, arbitration has to adapt to such claims and has to be open to such claims, or otherwise arbitration will become irrelevant for that part, which is a big part of the possible, let's say, market share of arbitration in dispute resolution. First, the procedural flexibility. So you're not stuck with more rigid national procedural laws. You have the possibility to have multi-party, multi-contract arbitration. You can adopt either, depending on the circumstances, you can adopt a confidentiality regime, but also transparency regime. Transparency is often said arbitration is not transparent. If I compare it, for instance, to Austrian court litigation, I would submit that most of investment arbitration is more transparent than court litigation, because you have all the decisions published, including the names of the parties, which you don't have in many domestic jurisdictions. You can go to the hearings, but that is it. You don't, or not always, see the judgments. And as I already said, there is a quite flexible regime regarding the applicable laws, allowing arbitral tribunals to take into account international law, general principles of law, rules of law, including possibly all sorts of soft laws. And to conclude on that, I would submit also that the arbitration practitioners show the necessary intellectual flexibility and curiosity to deal with such claims. Thank you.
Thank you, Florian, for great input. I would just like to stick more on commercial arbitration before we proceed with the with the investment arbitration. One of the major ESG themes, as I already said, is anti-bribery principle and corruption. Did you have any type of cases in regards to that in commercial arbitration? And what was the decision of the arbitration tribunal? Jovan?
Thank you. Yeah, I had. It's a very interesting case, and it's closed recently because arbitrator decided not to decide on the bribery practice, which was proven to exist, and it was sole arbitrator. It was connected with an infrastructure project in the region, involving international companies, insurers for the contractor, insurer for the investor. So it was a multi-party case, and the sole arbitrator was not from this region, and he decided that there is no arbitrability of the case because it's so connected with the criminal law of the country, which he was not familiar with. And his opinion was relying on the investigation that has to be done by government and governmental bodies dealing with how to say, fraud and signatures on different kind of papers involving parties' right to claim additional works and etc. I cannot say more, but actually it is actually existing practice, and we see it in arbitration. And unfortunately, we didn't have arbitrator's decision in a classic way here. Yeah.
Any thoughts on this?
Excuse me. What I will add, I will speak about corruption, about investment arbitration later. But with regard to commercial arbitration, what we can add about this is that the question of corruption and bribery scheme that can appear in the signature of different contracts is really is really in the center of the questioning of a lot of practitioners today, and not only and not only when you have a case. And that's why we have the development of discussions and debates among practitioners. And now I was searching of the name of the commission where I'm part of with Galina at the ICC, because in the ICC commission we have been working now for several years on corruption in arbitration and how to help arbitrators with a list of red flags that they can take into account when they see a contract or a case and where the corruption is raised before them, because for sure there are legal issues where the arbitrator doesn't have the jurisdiction to decide on. For example, whether there is, because corruption is all, you can see it from the commercial aspect of it, because it will render the contract void, for example. But you have the other aspect, which is the criminal legal issues, and on this the arbitrator doesn't have any jurisdiction. But also, the arbitrator doesn't have also the power to investigate on corruption. So the arbitrator is really limited by the demonstration, the argument, the evidence that are brought by the parties during the proceeding. So then it's also difficult for the arbitrator just to decide based on evidence that, on part of evidence, or if, we have this difficulty as arbitrator to determine based on few evidence where if we have all this the element that constitutes a bribery or a corruption, and what is based also on the applicable law, if this is a basis to render the contract void or to allow damages, for example. Because we have the last point, and I will end on this, is the applicable law. My understanding and my experience with domestic law with respect to corruption is that you have in some domestic law, you don't have anything about corruption or bribery. We think that it is, we know that it can be forbidden, but we don't have any legal issues and any, we don't have, any legal provision in some domestic law with respect to corruption or bribery. And at the same, so then we are totally linked. And I remember making some research in the legal framework of Tunisia, for example. What will I do if I have a case with corruption in an arbitration case with Tunisian law applicable? And the only thing that I found is that the only solution probably will be for an arbitrator to go to the domestic judge, because we need first a decision from a judge in the domestic order deciding that there is a corruption, that they are guilty of corruption. Otherwise, you don't have jurisdiction to decide. So it's quite a difficult issue in commercial arbitration, which is, and you will see that the answer for investment arbitration is quite different.
Thank
and I will
you.
come to it.
And Florian and Jovan wants to comment on this. Maybe Florian, can go first.
Yeah, I would probably have a kind of, would like to add a nuance to that. I think if you look at the questions that are dealt with in the context of corruption, you need to distinguish between criminal liability, and of course arbitral tribunals don't have the power and jurisdiction to determine criminal liability, but arbitrators are empowered and obliged to determine civil law questions usually. And the question whether there was corruption, so whether there was a bribe or something else prohibited under the law or an international convention, is usually a preliminary question to the civil law question. And I would submit that this hesitation of arbitrators to address this issue is misplaced in some cases or in many cases, because they are not deciding whether somebody should go to prison, but they're deciding the question whether a contract was tainted by corruption. And that's a different question, and probably arguably also under many jurisdictions subject to a different standard of proof. So I would submit that this attitude of arbitrators to say we can't determine criminal liability is misplaced, because they are not saying whether under the applicable criminal standard of proof somebody is criminally liable. They are deciding under the applicable standard of proof in arbitration whether a contract has been tainted by corruption. And as regards the evidence, I mean, of course, in the end, if there is no evidence, there cannot be a finding that there was corruption. But in many of the cases I have seen, and I was personally involved, the evidence, at least I would submit that, that there was corruption, at least in accordance with the required civil standard of proof, was overwhelming. And still, arbitrators were hesitant to find that there was corruption. So I would somewhat disagree with this very general stance. We cannot determine criminal liability, because that's not what arbitrators do.
Okay, thank you, Florian. Jovan?
Yeah, I fully agree what you have said now. It's actually, just want to add two important information about the case. It was not about criminal act of the parties involved in this bribery and fraud. It's actually about the claim arising out of the contract, which was obviously made by corruptive practice of the parties. So it was about civil claims, civil law question, and the opinion of the arbitrator was that claims arising out of the contracts which are based on corruptive practice are not, there is no arbitrability of such claims. It was connected strictly to the claim, not criminal liability of the parties involved. That was the opinion of the arbitrator. And the funniest thing is that once one of the parties submitted its claim to the court denied its jurisdiction because there was arbitration clause in the contract and didn't want to accept judging the case. So actually it's now a question how the parties will seek their justice here. And that explains to which extent, at least in regional practice, we are not aware of, how to say, dealing with ESG and governance and anti-bribery as the part and the component of ESG in arbitration and court jurisdiction.
Yeah, that was the reason why I mentioned corruption anyway. Any thoughts or any comments or questions from the audience at the moment? No. Okay. Then
there is no corruptive practice here. That's good.
Correct. Then I have a question for Afef. So since we're very short with time, maybe we can switch to the international investment arbitration. So how has ESG permeate the sphere of investment protection and investment disputes in the energy and construction sectors? And are there some lessons to be learned from the past disputes about the risks in this area?
Thank you, Armela. So my answer will be based on three elements, but as an introduction first, I want to say that we can see that there is an exponential increase in investment cases during the last 20 years. This is known. And some of those cases, and most of them, has raised issues concerning a state's ability to regulate in its own sovereign scope, particularly in area touching environment and social policy. This is not new. All the investment cases that started in the beginning of the century, for example, they had most of them this aspect, because the defense of the state was, we decided this, we deny the license based on policy order and generally linked to environment or social policy. It worked or it did not work, this is not the question, it is just an observation. The second one is, if we combine this with the awareness of climate change and the pressure on states to adopt ESG laws now for some since few years, and this is to help to mitigate the climate change and uphold human rights and ensuring good governance. So then we can just conclude that we will have more cases in investment arbitration, or we just can observe that in the last 10 years we got more and more cases involving this question of ESG, or meaning environment and social and governance. So it is true that this awareness of climate change and the pushing of a lot of NGOs and for the inclusion and for the adoption and to regulate the environment and the social question in every state will have an impact on investment arbitration for sure, and investors' claims. And in particular, when it is related to energy and construction, because obviously energy and constructions are sectors which are really governed by tougher environmental regulations with the increase of this awareness of climate change. So we have, as you described, Florian, with the examples with what is happening with the corporates, with the companies, and the fact that they have to be very transparent on standard with the application, their compliance with different standards regarding ESG. This is also going to be compliance with the state law, with the domestic law, because those standards of ESG are now incorporated in different laws, and we have a lot of, in a number of states, we are adopting domestic law with ESG concerns. So if you have in the domestic law ESG concerns and ESG obligations toward the investors and the different companies, but also the states and the organs of the state, those who are giving and allowing license to intervene in energy or to give mine license, for example, and also in construction. So then you have the potential, potential cases between those investors and the host states. So in my view, ESG permeate investment arbitrations in three different ways, and I will address them successively. So the first one will be how ESG is addressed as a ground for claims, on the one hand, and as a defense, on the other hand, from the host state. So this is in the dispute, in investment arbitration in general. But it has also an impact on two other aspects. First, in the drafting of treaties and the drafting of model BITs. So it is a consequence of it. We have a shift in the drafting of model BITs and BITs in the last years based on this awareness of climate change and the need to include ESG provisions. And we will discuss why it is important to do it, to include it, and in which way we can include it in BITs. And the last one, and it will be very short, it is quite quite interesting to see that ESG was also addressed in the debates that are already in course at the UNCITRAL Working Group 3, which is only discussing procedural issues. So it's only procedural. But at the same time, the question of ESG appeared at some point in the debate with the intervention of some NGOs and the calls of some practitioners. So I will first start with ESG in investment arbitration. So in this area, ESG may appear at different time, as I said. First, for the investor claims, and secondly, as a defense from the state. So it is not something new. I mean, we have a lot of cases in the past where the investors went to arbitration and claiming unlawful expropriation, violation of national treatment, minimum standard of treatment, legitimate expectation with respect to a fair and equitable treatment standard. And all of those were based on the fact that the state adopted a conduct which allegedly was grounded on environment policy or interest, but at the end was the basis of an unlawful expropriation, or can be demonstrated as being discriminating to that investor. So the question of environment was already discussed in investment arbitration. What is new and linked to energy in particular is that with the climate change awareness and the change in legislation in some part of the world, and here I will focus, for example, in Europe, in Spain and Italy and also France recently, we reached an arbitral tribunal were constituted to address cases against France, Spain, Germany, for example, the Czech Republic, and all of those were based on a change in the legislation with respect to energy. So we have those solar cases against Spain, for example. And in those cases, generally what was the base and the ground of the violation was the violation of fair and equitable treatment, and in particular legitimate expectations of the investor, which were frustrated after they have started investing in the country, and we had a change in the legislation with respect to energy and the obligation of the investors, for example. And based on this, the arbitral tribunal had to analyze whether there was a breach of the legitimate expectation, whether the state failed to provide a stable and predictable legal framework for those investors, whether the state was transparent. So you see that the beginning is the violation of a standard, the fair and equitable treatment, but at the same time, and then we look and we go through the different conduct that a state can adopt, and we have sub-obligation in a way, for example, when we go to transparency, and whether the state has acted also in an arbitrary and discriminatory way, and also whether that legislation or that was disproportionate based on the investment that was made by the investor. So we have more and more cases where the question of ESG is raised by the investor, and it is the basis of the claim. On the other hand, we have in our investment arbitration more defense based of the host state based on ESG concern. First, and here I'm going to just give a list and go quite quickly on those. First, the host state can use as a defense in the jurisdiction and admissibility phase based on ESG, saying, for example, the investment that you made is unlawful because it was established and created in breach of the host state's environmental law, and for this it could be denied the protection at this first step, or also admissibility. And this can work obviously, if you have domestic law, including ESG, including specific provision with respect to environment and social and governance, if you don't have them, so I mean the investment is in compliance with the domestic law, if there is no obligation to respect those standards and those provisions. And those were used also in particular for corruption. So we have a lot of cases like the Union Fenosa against Egypt, for example. I was in the team defending Egypt at the time, and we have worked a lot. And I can tell you, really strong evidence again showing that there was a corruption scheme, and we were not followed by the tribunal. And as you said, it was totally obvious, but at the same time, the domestic law of Egypt was not very clear on the anti-bribery system, and the signature of different contracts seemed to be totally lawful to the tribunal. So,
sorry for interrupting, but I have just one question. Couldn't you engage the expert witness for the signature?
For the signature?
For the signature of the contract.
I mean, when it touches to the host state, it is difficult to invite as witness the officials who may have signed something. This is for, but it wasn't this. The issue wasn't with the official here. Okay. But we are talking about a contract that was signed 10 years before, and some of the persons involved were not. We're not in Egypt and we're not in Spain anymore, and we could not call them as witness because they are not part of the arbitration, so we cannot oblige people to come and witness. So based on the document they signed, the contract, we had copies of the contract, and the scheme of the contract, it was evident that something was wrong. We got it was obvious that something was wrong in the contract, but if you don't have the witnesses, as you said, the people who signed to testify, and in a way they're not going to sign and say, yes, I agreed to this contract of agency, to help with the signature of this big contract with the state, because this is criminal, for example, for them. So they cannot, for this you cannot have witnesses at all. But just to go back to an investment arbitration, so this is a solid defense for states, but it is difficult sometimes to prove it. But on the other hand, we have arbitral tribunals who obviously obviously had rejected their own jurisdiction based on this ground. The same with the compliance with domestic law. An investment to be protected by a BIT should be established in accordance with the domestic law. Obviously, this will depend on the provision of the treaty and how it is drafted, and sometimes we don't have the in accordance with domestic law. But even in those cases, some arbitral tribunals interpreted the treaties in a way and where they rejected jurisdiction because they considered that the investment was established in contradiction and with the domestic law. And finally, with respect to environment, I can quote a case, the Kotok mining against Kenya, for example, where here, in particular, we had the arbitral tribunal decided not to recognize themselves as having jurisdiction because the investor didn't comply with the environmental law of the state when they got the license. And here again, they tried in 2007 to get the license. They took a long time to get a license, 6 or 7 years later. And that license was revoked 6 months after because of a change in the government, a change in the awareness of the environmental issues. And here again, the tribunal was able to decide that they don't have jurisdiction because it was contradictory to the law, even if, they got the license and it was revoked 6 months later. In a way, we can say that the state has changed its law, but no, the law didn't change. It is just the interpretation of that law, and the tribunal went through the interpretation and decided that in one way that it wasn't in compliance with the domestic law. Another way to make a defense for a host state is also to include counterclaims, to raise counterclaims against the investors based on investment and social and governance grounds. And here again, those counterclaims, we have two issues. First, whether in the BIT we have this possibility for the host state to raise counterclaims or not, and also, if you want to raise counterclaims, you need to have obligations in the treaty. You need to have a ground, even if you are the host states, not only domestic law, but also, why not, in the treaty. And with this, and the last element in the defense will be also the reduction of investor damages grounded on contributory fault or grounded on the idea that, okay, there is the state has violated the treaty, but you contributed in a way to your damages by violating environmental and human rights law. And here we reach a point today where the trend is to add in the treaties the possibility to make counterclaims for a host state, and also to add provisions with obligation for the investors with respect to environment and social and governance. And then adding provisions in the treaty where we are inviting, in case of a dispute, the arbitral tribunal will have to look and assess whether the investor's non-compliance with environmental or human rights law of the state will diminish his part of damages, and this trend is mirrored today, I think, in the Dutch model BIT and the India model BIT, for example. So with this, I'm reaching the last point, and I'm not going to be the second point, but I won't be long on the third one, is ESG in BIT. So with this, you understand that the consequence of the impact of ESG in investment arbitration is reflected also in the drafting of treaties, and the new model BITs, the new BITs that are now enacted around the world, generally include obligation for investors with respect to environment, social governance, but also limitation for damages and limitation for access to ISDS if you have violated domestic law. So if you have a strong domestic law, including ESG provisions that are not followed by the investors, so then you can cut the road to the investors to go to arbitration. And and the last thing is that the ESG came in the debate in ISDS reform at the working group. And here, the only thing that I want to say is that at two occasions, the question was raised by NGO. One NGO, for instance, it was Client Earth, who submitted a report proposing first carving out all governmental measures taken in pursuit of international obligation under the Paris Agreement on Climate Change from challenge through investor-state dispute resolution, meaning every measure taken by a state in application of the Paris Agreement on Climate Change, for example, should be outside the scope of any investment dispute resolution in BIT, but also allowing counterclaims by and ensuring full participation of the affected third parties, particularly in relation to the environmental impact, meaning calling for the participation of NGOs in investment arbitration when it touches to environment, social, and governance. The second one was not linked to the Group 3, but at the OECD, where we have one of our colleagues, George Kahale, who is a partner in one of law firms and who was involved in multiple cases as a representative of states, who called for a declaration of states. states declaration or interpretation, common interpretation, explaining that, saying that it is understood and agreed that measures taken by states to mitigate the effects of climate change do not constitute expropriation or a violation of the fair and equitable treatment standard incorporated in investment treaties. So a call of a sort of a general declaration of states to of treaties. And we know that, for example, that the common interpretation of a provision of treaties can have an impact in investment arbitration, because the arbitral tribunal can be linked and bound by that interpretation by the states, because the ground of investment arbitration is a bilateral investment treaty or multilateral or regional treaty, for example. And with this overview of what we have in investment arbitration, I will just conclude that we can also add those in investment contracts. It's not only in treaties, but also we can do this in changing the provisions in investment contract, adding standards as we do in commercial arbitration, I mean in contracts with construction and energy contracts. And with this, I would say thank you for being that long.
Any questions from the audience at this moment? No. Since we have to sum it up, I would like to talk about the prevention of the disputes. And given the multi-contract and multi-party arrangements in energy and construction projects, Jovan, is there a way to mitigate risks through contract design and negotiations with the parties? What is your experience?
Yeah, that's,
and advices, of course.
Yeah. Traditionally, construction and energy contracts are relying on applicable law in the country where the project is to be performed. So it depends to which extent the regulation and applicable law of the country is actually dealing with ESG. My experience shows that some components of ESG, for example, G, governance, is traditionally included in some of, how to say, most used contracts and model of contracts in the region. For example, FIDIC contracts, we have this health and safety, modern slavery, anti-bribery provisions, and it's actually traditionally included in the contract. There are problems with social and environmental components, and as I said, they depend, first of all, in my opinion, on culture and, how to say, business and social culture of the country. We see now in the region, how to say, very different consequences of ESG requirements in our energy sector. For example, citizens, they are against feed-in tariffs now because they don't understand why the same quantity of electricity in their electricity bills have a different price. You know, for them that's the same thing, you know, but they have to pay more. On the other side, we see how, and I suppose you know that it's about Serbia, how some mining projects are on the level of political problems, regional political problems, because people are very interested in protecting environment, and they're, how to say, they think that their future is actually in risk with such projects, and they insist on high ESG standards. So social and environmental...
Can I interrupt you? Then what are the consequences for the state in that case?
Okay, it's now we have to go back to this investment treaties and relation between the state and the investor and the, how to say, foreign contractors and investors. What we see as a problem is investment disputes for, how to say, many projects which are not, they didn't start now, they started 20 years ago, and there is a, how to say, huge amount of money invested in researching, developing projects. So yeah, it will be raised on the level of the state dispute, probably. On the other side, we have commercial arbitrations and, how to say, contractual aspects of ESG in complex multi-party construction contracts. FIDIC launched last year this global climate change program, which announces that there will be a set of ESG rules contractually dealing with ESG. There is no such set of rules now, apart from these anti-bribery, health and safety provisions and modern slavery, of course. But what we expect is to get one, how to say, international set of rules which will be, of course, adopted from the country to country. Now we don't have it. I suppose that FIDIC is still most used model of contract here in Bosnia as well. Probably the audience can confirm it, but actually we are relying on FIDIC as and different books of FIDIC as a most used model of contracts. And what they're insisting on this net zero criteria and how to say low carbon requirements through this decreased footprint on the projects. And we expect to have this set of mechanisms and rules introduced probably next year or within 2 or 3 years, where engineers and consulting companies will be obliged to apply some ESG reports and monitoring tasks. So, as I said, from the perspective of governance and these anti-bribery and health and safety provisions, they're traditionally included in the contracts. The biggest problem is with environmental requirements and how to provide mechanism that obliges contractor or investor to apply environmental rules. And I want to refer to what Philip said today when commenting the regulation and policies of EU. There are countries which are not included in the European Union, and we are facing a lot of different standards implemented. And I will give you an example of the public investor in Serbia, which deals with West investor on the one side and Chinese investor on the other side, where it's completely different what these sides, Western contractor and the Chinese one, expects from ESG reporting. One insists on it, so actually the public company has to accept, and once they want to apply it to the East investors and contractors, they simply reject it. And a lot of these projects are tied with financial arrangements, which are from either EU funds or funds of Chinese Exim Bank, etc., etc. So it's really easy to say what is a set of rules, ESG rules in such countries, because they, I think, on this regulatory level, they do not have, how to say, developed culture and the strict structure of regulation, in which way to go. Once we will have it, for sure, but at the moment, and as I said, the society is also not aware of it. Once they have to pay for the green energy, it's actually a problem. And on the other side, once they see foreign contractors, moving the lake, natural lake, from one to another part of their country, it's a kind of risk for them. So it's, at the end of the day, depending on the culture, of the society, and of course the regulation that countries want to promote. And to conclude with that, standard and traditional methods and mechanisms are penalties. Of course, ESG reporting. There is a case for termination of the contract. So it was the case before one arbitration panel, international arbitration, where there was no financial consequence of the ESG requirement, but actually it was about termination, whether the termination was based on contractual criteria, or it was unlawful termination because there was not, there was not reached limited emission of the dust from the technology implemented in one energy project. So at the end of the day, it ended up as dispute with contractual claim because there was no ground, and that's what's recognized by the international arbitrators. There was no ground for termination because the standards expected and applied and stipulated under the contract were different from what the regulation expected. So it again comes to the way how we draft and create contracts, because sometimes local regulations are different from what we stipulated and which kind of rules we want to apply there. So actually it's not easy to respond when you deal with such countries and countries which are not part of EU or which are developing countries. You actually have to understand, the first step is to understand what is the regulation and what is the governmental attitude towards it, especially because of different standards and different attitudes against different investors, and to which extent you are independent from those who are investing in your country. So, having in my time, I will conclude with this.
Thank you so much, Aaron, but I think Florian had a comment.
Very short. Just one basic comment on investment in the energy sector and sustainability. Sorry. There is, I think, a fundamental dilemma in any investment in the energy sector, which is that the lifespan of a power plant is 15 years to 70 years if it's a hydropower plant. And hydropower, any power plant is only profitable for the investor after a very long time, usually 10 years or more. Before that, the investment is a loss. So it is essential for any investment in the energy sector that the investor is allowed to have a decent return on investment, and that means that the regulatory framework, or let's say the economic framework, remains stable for a long time. And of course, there is a direct tension with the right of the state to regulate. And that is, I think, the underlying dilemma that is underlying Vattenfall and many other investments in the energy sector. If you want to attract private investment in the energy sector, you need to provide stability, and if for whatever reason you change the policies, there needs to be some compensation, and the same applies also, of course, for investments in the renewable sector. And that's basically a response to Philip. I wouldn't advise the governments, even in light of the current EU policies, to withdraw from these investment protection instruments, because I would submit it is an essential factor to attract private investment in the energy sector.
Thank you, Florian. I think that we have to sum it up at the moment. Thank you very much.
Maybe a question from the audience.
Questions from the audience?
Philip.
Okay, so we're not summing it up.
Two questions. First, why do you believe this state that wants to accede to the EU, why did the EU member states can regulate without any compensation, but a state that wants to accede to the EU, like Bosnia, which is much less money than average member state, should take compensation if it wishes to change the regulatory system? Where is the justice here? And second question, do you really think that an investor would say, okay, I'm going to go there because this is ECT member states, or is it rather that you look at the regulatory framework and the integration in the entire market? And if it is an integrated market, if it has transposed certain rules to its national legal system, will the investor really care whether this country is an ECT member state or not?
I mean, I can only answer based on my own practice. From advising energy companies, I would say that ECT or investment protection in general is a very, very relevant factor for investment, not only in this region but also within the EU. Is the first part of the answer. The second part of the answer is, from what I know, many energy companies are in Western Europe are cash rich and in need of projects and wish to invest in energy projects, but for whatever reason cannot with the speed they would like to do it. And I think providing a stable framework, and I would say that investment protection is a very relevant part of this framework, plays a very vital role in increasing the investment flows.
Any other questions from the audience? No, I like. Okay, we have a question.
Better. So I'm from the NGO sector. I'm a lawyer by the expertise, environmental lawyer, and recently my colleagues and I are promoting legal changes in hydro sector, and we were quite successful the last few years because we tried to stop the investment in small hydro. So I'm not sure when you mentioned that we should not, as a country, stop promoting the investment. Is it this related to the small hydro or just for the large hydro project?
I think I'm generally aware of this, of the debate and also of the legal implications. What I can say is that any energy production, whether it's so-called green or renewable, has an impact on the environment. So even wind and solar power plants are not impact-free, not at all, actually. Be it the destruction of the landscape or other things, yeah. So nothing is impact-free. The question is really what impact. Weighing the negative consequences. What is acceptable to society, and that's really a question that the legislator has to answer. I personally would say that at the moment the dramatic issue we are facing is climate change, and that any investment in changing the greenhouse gas emissions are important. But of course, we cannot pretend that this is impact-free on the environment, not at all. It will have an impact. The question where the danger, what is the bigger risk? And that's a question ultimately scientists also have to answer, and this applies to nuclear energy, anything actually in this sector.
Thank you, Florian. I do believe that we have to finish with today's panel. I do invite you to continue this discussion at the lunch. We have a lunch here in the hotel, in the restaurant actually. Firstly, I would like to thank all of my panelists today, and thank you. I do believe that we all enjoyed this very interesting and fruitful discussion.
Welcome back, ladies and gentlemen. It's wonderful to see you. We know that after the lunch break, it's always difficult to separate yourself from the chats and also some relaxation. So we hope we can hold your attention for another hour. I'm sure that this panel will certainly do that. I'm very happy to now announce the third and final panel of the 8th Sarajevo Arbitration Day, moderated by our colleague, Ms. Arnela Maglic. And they will discuss ways in which treaty-based dispute resolution mechanisms can contribute to sustainability and sustainable development. So we are very excited about this discussion, and we are sure it will be fruitful, just as every other.
Thank you, Fahira, for that introduction. And as the third and the final panel of the day, we have the task to tackle the topic of pursuing sustainable development through treaty-based dispute resolution mechanisms. And we have heard here today of how growing concerns regarding sustainability have reached a tipping point and have prompted important advances in international policy in this regard. However, these advances are only translated into real change when efforts for sustainable development are aligned with the legal architecture behind the global economic governance and are promoted by dispute resolution mechanisms they contain. And in order to see where we stand in this regard, today we will look at the new developments in international legal framework that can promote the right, sort of say, type of investment in response to state sustainability development agendas. We will also discuss the growing number of investment disputes that show how high the tensions can arise between commercial interests of certain investors and local development agendas, and the roles that different actors from investors to institutions play in this regard. And although for guests here that are members of the arbitration community, my panelists here don't need much introduction, I will nonetheless do so in a couple of sentences. We have here today with us Dr. Galina Zukova from Zukova Legal, who is an arbitration practitioner with over 20 years of experience. Dr. Zukova acts as arbitrator and counsel under the rules of leading international institutions and also acts as an expert in international arbitration proceedings. We have next Mr. Stephen Pinizio, a partner from WilmerHale London, who has significant experience in commercial and investment treaty arbitrations. He has acted as arbitrator and counsel in both institutional and ad hoc proceedings, which involve laws in various jurisdictions from Europe, Asia, Africa, South America, and the US. Next, we have Ms. Neem Blameweather, and she is the current Secretary General of the Vienna International Arbitration Center, or VIAC. And prior to taking her role in VIAC, she was actually the principal associate in the disputes, litigation, and arbitration team in a top-tier international law firm in Vienna. Ms. Blameweather also has significant experience in complex construction and energy proceedings. And last but most certainly not least, we have Andrea Zubovic-Davedzic from CMS Sarajevo, who is a bar-certified attorney at law and one of Bosnia's leading commercial law practitioners with over 15 years of professional experience. Her main practice areas are corporate and commercial law and banking and finance. And I would now like to start off the discussion with a question that I would direct to Galina. We have heard today, and also it's a common knowledge, that there is now widespread acknowledgement amongst governments, civil society, and progressive members of the business community that these mandatory comprehensive measures are needed in order to hold business actors accountable for actions in regards to sustainability. Now, I would ask you, what are the new contents of international public policy in this regard, in regard to compliance in environment and also human rights?
Thank you, Bella, for your question. And I think like two preliminary remarks call on my side, if not three. First one is obviously like it's a massive pleasure to be here in Sarajevo. This is my first visit, and I'm thankful for the invitation. And it's impressive to see this discussion here. It's very nice to see the city. So thank you so much. The preliminary remark number two is it is an extremely difficult task, I think, like for all of us, definitely for me, to speak after panel one and panel number two, because they have covered all our topics which we're supposed to cover. So we are really improvising here, and in my speech I will be making a lot of cross-references to panel number one and panel number two, basically saying I agree with what has been said before. And now coming closer to the question, right? I think like the question was posed in a way, you know, like how to, there's a consensus to hold business players accountable. And I think it's a negative, something like a negative in this question, right? Which calls like to categorization, you know, like there are good guys, i.e. the government, and there are bad guys, i.e. the business. And I think this is not a right characterization. You know, like if we go to this juxtaposition, I think we arrive nowhere. It's definitely, you know, like what we're trying to achieve can be achieved only through the joint efforts of all players, including the government, including the civil society, including businesses, and so on and so forth. So we should be, you know, like not trying to accuse anyone, but trying to find a solution to the problems we're facing. So here, I think, few aspects which I have to cover in my presentation. First one, and this is what has been already mentioned, there is a recognition that the governments have right to regulate, right? I think we cannot take away from the government this right, and this is their duty to regulate, you know, like to regulate, you know, like to set aims, climate change's aims for all of us as a society, and also regulate the behavior and duties of the businesses, right? So a lot of treaties, a lot of framework agreements have been mentioned, you know, like obviously the ECG Treaty was mentioned, Energy Charter Treaty, the Paris Agreement was mentioned. The one big thing which hasn't mentioned in this conference so far is the outcome of a COP27, you know, like which was reported like these last days. And what I was reading yesterday on Instagram basically is that they also have reached the new climate deal, you know, like basically 200 countries signed to it, so we are still to read this. But this is something on a big public scale, this is what we have now. This is one way of regulating. Another way of regulating exactly is the behavior of the private players and of businesses. Not so much or exclusively in investment area, but generally. So here we have different initiatives, and I will mention only two initiatives which are moving forward, which are not the legislation in place. One is in the EU and another is in the United States, and which to a certain extent mirror each other. So we have a proposal, EU proposal for a directive on corporate sustainability and due diligence, which was adopted with proposal in February this year. And at the same time, we have US Securities and Exchange Commission proposal for rules to enhance and standardize climate-related disclosures for investors. So basically, what do we have here? You know, like both proposals aim at the large companies, like especially in the EU, there's like a definition of what is a large company under this proposal. These companies, they have to integrate ESG due diligence into all of their corporate policies and identify in their plans actual potential adverse impacts on human rights and environmental impacts of their businesses. So this will be a must, right? So this is how we're trying to regulate this area. The same thing is the United States, where the Commission proposed, SEC proposed rule changes that would require registrants to include certain climate-related disclosures in their registration statements and so on and so forth. So this is how the government regulates the players' behavior. Now, if we move into the investment field, in the investment field, you know, like obviously, you know, like the specialists much better than I am in modern BITs, but BITs, like classical BITs, when we had provisions in relation to environment, normally these provisions contained in rather general language containing the duty, the obligation, the undertakings, good undertakings of the member states, of assigning signatories to the BITs to care also, like let's put it this way, about environment, but not duties of investors in this field. So now we see in new generations of BITs where duties are also imposed on investors. So let me look at one of the BITs, you know, like one of the recent ones. So an example here is this language, you know, like a classical language aimed at the state. Nothing in this agreement shall be construed to prevent a party, a state, from adopting, maintaining, or enforcing in a non-discriminatory manner any measures otherwise consistent with this agreement that considers appropriate to ensure that investment activity in its territory is undertaken in a manner sensitive to environmental and social concerns. So this is for a member state. From another side, investors shall conduct a social impact assessment of a potential investment. So this is number 2. And then later, what investors also have to do, investors and host state authorities shall apply the precautionary principle to their environmental impact assessment and to decision taken in relation to proposed investment. So, this is a collaborative effort. The same principle of collaborative effort, the same principle of precautionary, which we should apply in whatever we do in our business, is also incorporated in the new proposal for the Energy Charter Treaty modifications as kindly provided to me by Karina. So here we have a new Article 19, which is not called environmental aspects anymore, but sustainable development, and which says that recognizing the right of each contracting party to determine its sustainable development policies and priorities, to establish its own levels of domestic environmental and labor protection, and to adopt or modify accordingly its relevant laws and regulations, and so on and so forth, right? So this is, again, collaborative effort. So this is regulatory functions. Now we go what is happening in the investment fund. And here, what I wanted to say basically was covered by Ilya and Karina in the first panel. So arbitrators, they are not deaf to the sustainability or environmental concerns. One thing, as was correctly pointed out, is a big number of new investment cases brought under the specifically Energy Charter Treaty. Another thing is what is the outcome of these proceedings. As Karina has showed, this is not like in all cases the member states, the countries are losing. Quite the opposite. It's only in 50% of cases roughly. It goes to one way or to another way, and obviously the damage which is awarded is not the original damage quantum claimed in these proceedings. So here what the tribunals have done, they looked, here I'm cross-referencing Ilya, right? They have to look what was, if there was at all, exact promise, exact undertaking given by the member states to a particular investor. What is the scope of a particular promise? If there was not a particular promise, but a regulatory framework addressed to all, then you have to look, what kind of legitimate expectations could be created on the investor side, and then we have, of course, this is an analysis, you have to go into this, but, what is the scope of this, and what is the extent of these legitimate expectations? And if you come to the conclusions that, yes, certain legitimate expectations were justified, then you have to go to the quantum. And this is, again, yet another analysis. And here, again, the arbitrators exercise certain, not only discretion, but also restraint, I would say. So this is number 2 of my presentation. And like the third, you mentioned the term of international public policy. International public policy, some people would call it, other people would say this is a different thing, transnational public policy. So I think here we have to ask, the first question is, what is this at all? Because public policy we understand, what is public law we understand, what is transnational or international public policy. So I try to identify it. So one of the definitions what I found, I will go for a short while, is an international consensus as to universal standards and accepted norms of conduct that must be applied in all forums. So it's a consensus. So we don't have a written rules in this respect. What is international public policy? A good example, an obvious example of international public policy was already mentioned in panel number 2. This is a corruption, right? I mean, this is true, and now we understand, no investment which was procured by corruption should be protected, let's put it this way, and rewarded if there is a stage of international investment arbitration, if there is a dispute. So far, so good, right? So are these concerns about environmental matters, sustainability, aims, objectives, and so on, also form part today of international public policy? And this is a question. And I would submit that we are in the process of creating the new scope, complementing this scope of international public policy. If we go back to the corruption, there's a decision, one of the first decision given by Karl Lagerfeld in the 50s, when he said arbitrators don't have at all arbitrability, I don't have jurisdiction to rule on corruption matters. Today, 60 years later, we take it for granted, so back then in those days, it was still, the area which was not actually forming part of international public policy. And look, it took almost 60 years for us to arrive at a consensus that it is, right? So now we're in this, I would say, in this making process, whether environmental considerations, sustainability consideration, all also make part of international public policy. And how we are measuring this is difficult to measure, but we measure it by looking at what the arbitrators decide. We are looking massively into what the national courts decide, and again, there was references to a lot of interesting decisions. And I think, this, what forms the scope of this new transnational public policy for the arbitrators and for the national courts alike. Here we have to be aligned in our reasoning, in our approach. Once again, we as arbitration specialists, as arbitration practice at all, generally, we are dependent on the states and state courts, tribunals, policy vis-a-vis us. So, of course, if we as arbitration specialists, as counsel, as arbitrators, we are deaf to the concern of the general, civil society, of the governments, to the climate objectives, to environmental objectives, aims we're trying to achieve, we will lose legitimacy in this market. So we have to pay attention to this. And I think this is somehow makes the background to our discussion, but I think, again, I compliment panel number 1 and panel number 2 because a lot of these aspects were already brought up. Thank you.
Thank you, Galina. I just have one question to add on to that. You've mentioned the new generation BITs and the language that is more aspirational than a firm obligation that they contain. I mean, we can all agree not all of them, certain model BITs that are being negotiated do contain firmer language than others. But with this aspirational language contained therein, what do you believe that there would be room for the arbitral tribunals to make decisions which would be more in favor of protecting sustainability and denying benefits to these investors based on that language, or it would turn the table and go other way around?
No, of course. I mean, it goes per se, but I think these are all processes which are happening at the same time, so there is a change in the language of the BITs. You just have to take it into account. You have to take, you have to understand and you have to give weight to the fact that the language has been changed. You can't just ignore the changes in the legislative framework. Then, of course, there's, as I said, there's a number of conventions, there's regulatory initiatives by the different states, which again reflect each other. Maybe there will be, and there always will be, discrepancies between one jurisdiction and another one, but of course, mandatorily, arbitrators will have, and I think we already do, pay concern to these changes because, and here we come to the institutional rules, the general principle of arbitration as such, but also arbitration rules. Your primary objective, or one of the primary objectives as an arbitrator, is an award which will be enforceable. Right? So if the party will go to the state courts and say it's not enforceable because it just disregards the legislative framework of this country, disregards completely, the aims which we're trying to sustain and, to which the government has subscribed, then this award will fly out of a window. And not only this particular arbitral tribunal will suffer, for the reputational loss and so on, but the entire arbitration practice, right? I think so. So, for sure, the answer to your question is for sure they have to pay attention. Thank you.
I would now invite Stephen, if you have any comments on because we're in the dispute, started the discussion regarding the dispute section, and as counsel, maybe there's a comment that you would like to add.
Can I run for a little bit? I want to comment on what Galina said, but let me start by saying, as Galina said, we covered all this twice already, and so we're going to be a little bit more ad hoc in how we do this, but the idea is to build on the discussion that's been happening all day so far. And I guess from my perspective, let's take a step back. We're at Sarajevo Arbitration Day, so we want to talk about arbitration and sustainability. And what do we mean by sustainability? What we really mean is climate change, environmental issues, sustainability. We mean human rights. So let's talk quickly about how do we get human rights into arbitration? Where does it come in? Because traditionally, when we talk about climate change, environmental issues, it's happening at a state-to-state level through the ICJ and mechanisms like that. It's happening through states prosecuting or regulating locally. So where does it come into arbitration? Because there's a possibility of an arbitration mechanism in various climate change and environmental treaties, but those have never been taken up. And again, that's state-state. And what we really want to talk about is how do states defend themselves? That's what we were talking about when we're talking about investment treaties, but we also wanted to, I think, talk about how do states actively bring claims against polluters or people who breach sustainability goals, and what are the mechanisms for doing that, and does arbitration play a role in that? And why do we care? Because states have the prosecutorial and regulatory power within their four corners, but if a polluter is sitting in a different jurisdiction and has very little in the way of assets within the state has a toothless remedy if it's prosecuting or regulating locally. So I want to quickly just think a little bit about where we're moving, both to talk about the reform efforts within investment arbitration, and you've heard a lot about that this morning. Let me just highlight a few things on that. One is we have two streams of reform. We have substantive reform and we have procedural reform, and the efforts so far have focused more on procedural reform. And so we see ICSID failing to do anything substantive, tweaking procedures. We see the working group 3 trial stuff really focused on an investment court, on advisory center, things that are, again, not the substance of rights, not the substance of obligations. And I don't think that's the place, frankly, where that discussion should be happening. So where does it need to happen within the treaty space? It needs to happen within treaties, within either discussions of how we're going to frame new treaties or reform other treaties. And despite the mess we've seen now with the ECT and all the complexities, and we can go in circles for what was happening there and what might still happen there, there were certain things that I think are important and when we think about reforming treaty rights, and that is there was this notion of tweaking in a thoughtful way the definition of an investor, and particularly a protected investment. And that's, again, how generally across different treaties we can start to address some of these issues. What is a protected investment, and are certain types of industries not protected? There was no effort, and I still haven't heard anyone define fossil fuels. So that's an important thing. But to define what the investment is, then you had the notion of clarifying the substantive standards. What is fair and equitable treatment? What does it cover and what doesn't it cover? And that's a space where there's a lot of room to create clarity that would help both investors and states if there was more predictability about what is protected and what's not protected. The ECT reform was also trying to deal with what indirect expropriation meant. Then we build in the flexibility mechanism that we've talked about this morning, as well as this review mechanism where every 5 years you would review the state of the world and consider whether the treaty needed to be modified. So that's the sort of approach that needs to be done, but I think it needs to be done even more effectively through ECT has got so many issues, but we see other places in the world where that effort is going on, and a place that doesn't get enough attention for this is Africa, where there has been really thoughtful efforts to attack these issues. The Pan-African Investment Code and the Africa Continental Free Trade Agreement both have very thoughtful approaches on not only defining goals that aren't just aspirational, and aren't just state-state like there was a reference earlier to the Dutch New Model BIT, and you were Galina was sort of coming back to that, this idea of the states to a treaty having some recognition of obligations that are environmental or human rights related. There are in the African, both the PAIC and the African Free Trade Agreement Investment Protocol, there are efforts to make more practical goals and put obligations on investors, and we see that now in some of the new model bits coming out of African countries. So if you really are interested in this, look at the Morocco model bit, which not only requires economic contribution like many BITs do, but it has performance requirements related to sustainability. That's where we can start to create these obligations. It's not just collaboration, but it's also performance obligations. And I think that's the direction we should be looking when we're talking about reform. Because I don't want to take too much time, I want to quickly mention something that no one's talked about, I don't think, and I apologize if someone said it this morning, but it's counterclaims. Right? Most treaties, there's a very big question about whether or not you can bring counterclaims. It depends on the language of the treaty. We are now seeing at least a few examples in treaties where there is scope to bring counterclaims, successful to a degree, counterclaims by states for failure by the investor to do environmental remediation. So the most well-known cases are a couple of cases against Ecuador, where in the Parenco case, for example, while Parenco won something like $350 million in damages for Ecuador's interference with its project, the tribunal also found it was knocked down from 90 million because of double counting to about 50 million in favor of Ecuador on a counterclaim, which then was obviously set off against the amount owed to Parenco. So that's, if we want to give states more opportunity to bring affirmative claims and the option to choose, do I want to do this to an investment treaty, where at a minimum it's a defense or a set-off, but also potentially allows me to enforce internationally as well. Maybe we need to be thinking about, it's a procedural reform, but a reform that says states can bring counterclaims. And then just to bring it all together and let other people talk. The previous panel was talking about performance requirements, which is why I kind of direct your attention to the Morocco bit. But that's also how we can bring climate change, sustainability, human rights into commercial agreements. And I think it was mentioned in the previous panel that you could put this into investment contracts. But the more that states can put, or state-owned entities put performance obligations into commercial contracts, you then have a place where we might see arbitration of some of these issues, and you have a two-way street. It's not a one-way path where the state is subject to claims and may have defenses. It's a chance for states to have affirmative opportunities to go after the people who may be at fault for some of the issues we care about with climate change. And so that idea of putting in performance obligations, and actually there are investors who don't mind this. You know, there are lots of investors who, for both cynical and genuine reasons, don't mind having those obligations put into commercial and investment contracts. So that's another place where we bring arbitration in. And then let me when we talk about human rights, I think sometimes this is widely known and sometimes it's not. There's also the model from the Bangladesh Accord. And I think that's something worth thinking about. And if you don't know the Bangladesh Accord, this was after fires in the garment industry in Bangladesh and lots of deaths in factories. There was an agreement reached among the garment industry companies who use factories in Bangladesh to create a code of conduct. And then there's a whole process which leads to, if there's a challenge to a company's behavior under the code of conduct, it goes to a panel, advisory panel, but then there's a right to arbitration that comes out of that. And that's the sort of mechanism that with cooperation you can bring arbitration again into solving some of the sustainability or human rights issues that we're talking about in a way that's a two-way street and not just a one-way street.
Thank you, Stephen. And I would just add, when you mentioned that there's investors who don't mind these standards, I would just add it's not only that there are investors who don't mind, there's also investors who count on it, who mustn't be forgotten. We're also a topic of their own discussion.
And when I say cynical reasons, because sometimes their investors, you know, they're public companies and their investors insist that they agree to abide by ESG requirements. And so there is opportunity there. And you know, we should be cynical about all this, but we should think about how to use that cynicism constructively.
I completely agree. And now while we're discussing different actors, or better said, different stakeholders in this topic, I would also say that this discussion on substantive issues isn't only limited to these stakeholders that we've now mentioned, but is also, is not only isolated to them, but is also a potential for arbitral institutions to bring a meaningful change in this field. And I would ask you, Neem, as a representative of one, do you find that there are certain issues that could be used as tools, such as cost and duration of proceedings, consistency of awards through maybe scrutiny, that could be used for promotion of sustainability in this treaty-based dispute resolution?
Thanks, Arnelia. And thank you to join everyone in saying thank you to Association ARBITRI for having me here. It's my first time in Sarajevo, and it's been fantastic since I arrived last night. I can't believe it's only 50 minutes away from Vienna, and I don't know why I've never been here before, but you know, I'm going to break that bad trend from now on. And also congratulations on the fantastic panels this morning. So when Arnelia posed this question of the view of the arbitral institutions, my initial instinct, and don't quote me on this, was we've signed the Green Pledge, so we're done. But I think, you know, we probably do have a bigger role to play. And given that we're referring to all of the other panels, because that's what the last panel does, what Philip Boras was saying this morning in the first panel, I thought was really interesting, because, you know, he was focused on this market here in Bosnia, and he kind of highlighted 3 points that, you know, in order for the market to develop in the energy transition, these steps would have to be taken. And I'll just jog your memory in case you weren't listening to him. The first point he made was opportunities in the market, so green hydrogen and you know, potential projects there, and the requisite infrastructure that we need for this energy transition. The second point was implementation of legislation, and the third point he made was the liberalization of the market. And then he posed the question of, you know, what will the investment framework be in order for, you know, if there are then disputes coming out of this market. And I said to him in the break, I think I have the answer to that question. So, you know, if we think about the energy transition, that's kind of what Philip is saying. It's an opportunity for smaller markets and smaller players to maybe, you know, dabble in some kind of renewable energies or in infrastructure. And of course, we know that the bigger players have the bargaining power to negotiate protection for themselves. But what will the smaller players do, and what do the states do? And like Stephen just said there a moment ago, you know, how do states bring claims against potential polluters? And that brings me to my potential solution, which is the Vienna investment rules. So I don't know if many of you are aware of the fact that the VIAC enacted new investment rules in 2021. So they're very much in their infancy, they're very new, and we're kind of in the process of, you know, bringing them to the market. And the idea, it was a, you know, working group of very smart people who, you know, really kind of tried to look at the market and consider where there is a potential. And I think what they saw was that there are a lot of smaller investment disputes that are kind of fall between the gaps because, you know, they don't have the requisite money or whatever else one needs to go to ICSID or to have a large investment dispute. So the idea of these rules is to create that possibility for those smaller players. And I think if you look at the ICSID, you know, the new ICSID rules, there's a reflection there that there was a need to create a possibility for lower value investments or for smaller investors with a focus on this region. So if I may, I'm just going to talk through, because Arnelia made the, you know, point about cost and duration, and I'm just going to, without boring you with provisions, because I know that that's the worst thing to have to listen to when you're between this and a cocktail. I just want to highlight a couple of the aspects of the rules that kind of try and make it as cost efficient as possible. And one is that there's no jurisdictional requirement, so any of you that have done ICSID cases will be familiar with that. So it's simply up to the parties to decide whether the Vienna investment rules are suitable for the resolution of their dispute. And as a result, that should basically, you know, you should save an awful lot of time and cost on jurisdictional battles. The second point is that the investment rules allow for the dismissal of frivolous claims at an early stage of the proceedings. So a party may apply for early dismissal of a claim, counterclaim or defence if it's manifestly outside of the jurisdiction of the tribunal, manifestly inadmissible or manifestly without legal merit. The third point is that the rules affirm the power of the tribunal to order security of costs. So the test for the security of costs is simply a sufficient degree of probability. So those of you that are familiar with ICSID will know that it's a much higher hurdle to get that through. And we know that, you know, states in particular, you know, it's always been a concern that the security of cost provision is very high. So that's kind of been made a little bit easier by the Vienna investment rules. And then 3 other minor provisions or major provisions, depending on your position, that encourage efficiency and speedy resolution of the dispute is jurisdictional objections must be raised early on, so no later than the first submission on the merits. A dispute under €10 million will be decided by a sole arbitrator, and the tribunal must render its award within 6 months. So that's kind of a summation of, or in a nutshell, the provisions of the investment rules. And I would encourage you to go on our website and have a flick through them and consider whether it is something that would be interesting in your practice. And the second point that Arnela raised is awards. And Galina, you said this. This is the whole interest of an institution is to administer a dispute whereby the parties get an enforceable award at the end of the day. And I was saying this last night that, we also try and go that extra mile for parties when they have their award. Technically, once it's signed and bound and it's fancy red and white paper, we don't really have anything, technically don't have to do anything with it, but obviously we try and go the extra mile for parties. And in the context of the investment discussion, I was thinking, what is the extra mile that an institution could go in the interest of in the public interest, because we know that the issue of consistency, coherence, predictability, and correctness of awards is an issue with the interpretation of treaties. And when we're in this, for what feels like, for me, the beginning of this sustainability discussion, I think it's all the more important that treaties are interpreted in a somehow coherent manner. And maybe this is my kind of common law background coming through, but just that we would establish some kind of coherent body of law whereby you can be relatively sure that a treaty will be interpreted in one way or the other. So if we look at the investment rules again, the non-disputing treaty party has the opportunity to make written submissions on the interpretation of the treaty, so I think that already contributes to what I was saying. And then the second point, and Florian mentioned this in the second panel today, because we're just tying it all together essentially. But Florian made the point about the publication of awards being so important for the public interest, and the Vienna investment rules also foresee the publication of anonymized summaries or abstracts of the awards. And also in the public interest details like nationality of the arbitrator, nationality of the parties, date of commencement of the arbitration, whether or not it's ongoing, whether it's been completed, and what instrument is relevant. And of course, the parties have the option of including the UNCITRAL transparency rules. And then the third point is the potentially controversial one, or the one that I would consider going forward. Like I said, the investment rules are in their infancy, so it's a new ground for us. But in order for consistency and coherence to really be solidified in investment decisions, and Arnela and I had talked about this in advance of whether or not scrutiny is a possibility, a useful tool. And at VIAC we don't have the official scrutiny that the ICC do, but we have what I refer to as scrutiny light. And when I started in the role in January, I thought, if we're trying to sell to parties that we're super efficient, and the reason that we don't have a scrutiny is also to facilitate the efficiency, that parties are not sitting around waiting for awards for 6 months. And we have implemented an internal deadline of 3 days. As soon as an award comes in, it needs to be turned around in that short period of time, which is kind of, at the Secretariat shooting ourselves in the foot in some situations. But, we do what we do. But in all seriousness, in the investment, when we look at commercial awards, we do look at the substance, just to make sure that it's consistent and coherent. And I think the obligation, and we make suggestions to the arbitrators or to the tribunal as to whether they might want to consider maybe a legal instrument or a certain aspect that they might not have taken into consideration. And I think in an investment sense, it would be even more necessary to do that we could advise arbitrators or suggest to arbitrators that they may want to consider an award where a treaty was interpreted in a different way, and if they do want to interpret it in a different way, that they may want to provide the parties with more reasoning. And I think that's something that a tribunal or an institution can maybe potentially contribute to a bit of consistency and predictability there. And then my last point is something that kind of has occurred to me over the period of our discussion today. We have been considering at VIAC to set up a working group to kind of look into all of these ESG type issues, and given that I feel like this is something that will be accompanying us for a long time, or at least until 2050. In an ideal world, then we're all sorted and we don't need to worry anymore. But to really look at maybe what is it that institutions can do, what is it that we as an institution can do, and in the context of that, I was actually thinking maybe it should be elevated to arbitral institutions as a whole. So the IFCAI, the International Federation of Commercial Arbitration Institutions, is always looking for mandates. There's 53 arbitral institutions in that federation. And maybe that's something that the institutions need to look into together, explore potential aspects of ESG and consider how we can do something, all of us together, for the common good, or, in the interest of sustainability. So that's my tuppence.
Thank you, Niamh. Thank you, Niamh. I would also invite Galina, Andrea, and Stephen, if you have any comments or anything to add on this point.
I would prefer to leave it to the end.
Of course, of course. And well, since we were touching upon different stakeholders here, let's now focus on the ones that are most talked about, and that is the investors themselves. And Andrea, I would turn to you now. In terms of the responsibility that investors hold in this regard, what is the role of social corporate responsibility? I works with employees that investors do, their families, local communities, society at large, to improve human life quality, the environment, and the economy, basically, in the long term.
How many days do we have for this question?
Well, let's start with minutes.
Well, firstly, thank you for the opportunity to join today's panel. Being a primarily commercial lawyer, I often deal with the investors and explaining what they can do and what they need to do to fit into the local framework. And dealing with a lot of foreign investors, I think it's just very difficult for them to navigate through the complexities of different levels of issues they need to deal with. Now, corporate social responsibility is not an aim anymore. It's not an objective anymore. We are far beyond that point. It has been enshrined deeply in day-to-day decision-making for most of the investors. And with ESG being the hot topic now, it should be an accessible performance outcome. And we all agree that that's still work in progress. It's very difficult to measure the standards and how do we get there. But it's an unavoidable aspect that every investor needs to look at. And I think that's where the problems come in. You've mentioned a lot of stakeholders, employees, families, wider communities, human rights, environmental. Now let's look at the governance part, the social part. We can look at this from different perspectives. One would be the general compliance with the law, but I think that's not enough anymore. It's not enough just to obey the law. So we need to take a step further. Fair labor practices. It also generally goes without saying that this is something that every investor would have to satisfy, not only on the local level, but the group level, global, regional, and so on. It also comes down to environmental concerns. And I think those seem to be given most attention in terms of the corporate social responsibility, measuring, and so on. Why? Well, in my experience, it seems to be the easiest one to measure, the outcomes. So what does an investor expect from the state where the investment is supposed to be taking place? What kind of regulatory framework and so on? What are the other investment treaties? How do they treat this matter? whether their investment will be protected in the context of any changes to the environmental laws. And this is where I'm going to mention something we've discussed earlier, the Ecuador versus Colombia case that seemed to be a groundbreaking case, right, very recent, in August 2022, where the environmental interests of the country were recognized as a legitimate interest to suspend mining activities of a Canadian company, right? So it's based on a debate between Canada and Colombia. And this new generation treaty included the carve-out for any compensation case of environmental concerns. But the tribunal seemed to disagree with both the agreement of the parties that there should be no compensation in this context because the reasoning for the suspension was the environmental issue, and it still awarded the compensation to the investor. Now we also have a different example, the David Avon versus Costa Rica case, where it was stated there was these carve-outs are applicable. So my point being here, how does an investor deal with the internal rules of corporate social responsibility, differing regulatory frameworks, and then differing practices? So yes, we do know that the things are progressing, they're moving slowly. We've heard it took us 60 years to get from point A to point B. But at the same time, I think what every investor needs to do is to understand the communities entering. And what Nia mentioned also regarding, for example, looking from a Bosnian perspective, the opportunities that were identified. At the same time, those opportunities do differ locally as well. In my personal experience, I work with a client who's a factory, so very much concerned environmental aspects of business dealings, a member of a global group, acting in different jurisdictions, involved in very environmentally friendly projects, and then the client slips, there is an incident, and there is an issue with the community. And they're a very good employer, so their employees, the employees' families do feel the good outcome of their engagement in the corporate social responsibility, not being just a tagline, but effective undertaking to do something for the community. And then there is the issue of the poor branding following one incident. So I think for every investor, and this is what we advise our clients, to try and understand what their investment exactly means, taking into account the specific circumstances of each and every community they're going to be entering. Cultural aspects, local legislation, local implementation of the legislation, interpretations of those, and then try to transpose the general view they have on the group level or in similar regions, neighboring countries, and try to make it more specific. This is the only way that they will be able to protect their investment truly, and to try to actually do provide some contribution to the community that they operate in.
Thank you very much, Andrea. Thank you, Andrea, for that. We've heard that investor holds the duty also that the investor holds the duty to be accepted by the local community, but we've heard that that is not an easy task always. But I would invite now Stephen.
I wanted to pick up on something that Andrea was talking about, because again, we're talking about it as investor responsibilities or duties. And I do want to make the point that the whole day we talked about treaty arbitration, we've talked about investor obligations, we're talking about reform of treaties, we're talking about expanding room to regulate. There was a discussion earlier today of the attacks and criticisms of treaty arbitration. I think Fahira started with this, and somebody mentioned the dirty secrets of the ECT and all these sorts of things. And some of the reforms we're talking about are things that are, somebody mentioned arguments for carve-outs for emergency action and no liability for emergency action. And let's also not lose track of the fact that there are rule of law implications. And one of the reasons we have investment treaties is because governments don't always act the way they're supposed to act. And let's not lose track of the fact that we don't throw out the baby with the bathwater, right? Because the investor protections have an important role to play with the rule of law, and it's very easy to attack the mechanism and suggest this is all one-sided, somehow protecting investors. But we also need to keep track of the fact that, you know, when we talk about the issues we're talking about today, sustainability and human rights issues, we're actually talking about a world where the rest of us sit here and watch while two bad actors often are playing, you know, big corporate interests who maybe not have your personal interests at heart, or and maybe small corporate interests, and governments who often, so we, you know, for the rest of us, we need to make sure there are mechanisms that work. And it's not one-sided. I mean, I think it's important that we don't so limit the protections for investors that we don't make sure that there is something that holds governments to account for when they act abusively as well. And that's partly the CCT issue, and we can talk about how it's protected fossil fuel interests. It's a more complicated question than the way it's reduced to simplicity sometimes, because bad actions by governments hurt everybody. And so I just wanted to make sure that part of it wasn't just talking about duties of investors, but also duties of governments.
And also, Galina, if you have any comments, I would invite you now to.
Well, with the comments, observations, I think as we were listening to our colleagues' presentations, you always have like either small questions or like something to add. So, for example, Stephen, when you were saying that the investors do incorporate references to their corporate social responsibility policies into their contracts, this is a normal practice nowadays, right? But it goes exactly hand in hand with what I was saying, you know, like these new initiatives at the US level, European level, you know, like, so there's regulatory like new narrative there, you know, like that businesses should report, you know, like the businesses do report, and those references will go into subcontractors' contracts, you know, like, so this is like an entire circle. This is where we all are in this, and everyone has to do its share of work with all this. I was very interested in hearing Nim's presentation with the investment rules, and it's interesting, you know, like, again, as you said, it goes hand in hand with the changes in the exit rules, right? So they have like this arbitration also for smaller claims, and they try to expedite it. For me, you know, this is a very attractive point, you know, like of having, you know, like you as a forum for, let's call it like regional smaller disputes. I think this is a good initiative. I see a future there. You know, like when you know, like where I was questioning myself, even with a small dispute of 10 million, you know, whether it's still feasible to do it within 6 months, especially, even more so, if the treaty partners, which are not party to a particular dispute, want to intervene as well and to present its own position. So there's like numerous aspects to all this. So, you know, like these were like the questions which I was taking, like which were raising in my mind, and about institutions' possible initiatives. You know, like I was like part of the institution myself, you know, like I was counsel at the ICC before, you know, like I'm an ICC court member right now, so like I have this institutional instilling in me. And, you know, like from one side, I see fully when you say, you know, like what can we do as institutions, and I see like sometimes institutions can do certain things together. You know, like we haven't spoken, this was not a subject matter of this conference, but on sanctions, you know, like what VX, Stockholm, CAM in Milan, these have done is impressive, right? But yet there's like basically 4 institutions together, LCA and ICC were separate, you know, like kind of, we move in the same directions but separately. So, you know, like this federation, I think it's a good forum, but how to get this voice to be heard together and to work on the joint project together, even though I think it's a very good idea, right? But just to get through it, you know, like how to get it done.
Yeah, thanks, Galina. Yeah, there are two really interesting points. So on the first one, on the realistic, 6 months, and I totally get that anyone in the room would think, oh God, a sole arbitrator appointment with a dispute, of that amount is still quite significant, and you have to use 6 months to draft an award. So on the one hand, the deadline can be extended. It's the discretion of the Secretary General. I hear she's very strict, but but actually we have an interesting provision in our rules that I don't know if people are maybe not that familiar with. So we have what we call a complexity a complexity bonus for arbitrators. So if an arbitrator has managed their dispute in a particularly efficient manner, or the case was particularly complex, it's within our discretion to increase the fees up to 40%. We find that this motivates arbitrators quite significantly to deliver their awards on time. Now, it's obviously, and this is because this is a question I always get by parties, and recently at a conference I had this lady very aggressively ask me, where you plan on getting this money, So obviously it's taken from the advance on cost, but the parties are obviously given the opportunity to comment on whether or not it is okay for them that the arbitrator has their fees increased to a certain extent. So I think that's a nice feature of our rules that maybe not everyone is aware of, and it does motivate arbitrators to deliver on time. And I think this is really an obligation of the institution to make sure that parties, to try and monitor the case to the extent that the parties get their award when it is expected. And then on the second point with the collaboration, thank you for mentioning the sanctions initiative. Maybe I am being a little bit idealistic, because the sanctions initiative that was launched by the various European institutions this year was extremely successful, because the unclear regulation was amended within 4 months and gave us clarity on whether or not we could administer disputes with sanctioned parties. But in my experience, if there's enough push, for something, like in that case, it was particularly for the institutions an issue of whether or not we can legally administer these disputes. So we had to stay proceedings because it was unclear whether or not what we were legally allowed to do. And I understand that the ESG topic is somewhat different. But I think it's definitely worth considering, that we should all kind of consider our obligations. And maybe the outcome is not a huge work product, but I think it's something that should be brought to the table and should be considered.
Thank you, Niamh. Since we're running out of time and we are the last panel, I see that there's many interested parties in asking questions. So
maybe if I just a brief remark, again, what comes to my mind when you say what the institutions can do, and bringing it, linking it to the topic of today, I think what would help and what the institutions, I think, can do is to give us example, to us, our audience generally, example of decisions of reasoning when the arbitrators had to reason on environmental matters. When this rationale of today came into the analysis and how the arbitrators cope with it. Because again, this is something what we are creating now, where we are working on all this now. And the council are asking, themselves, how to deal with it, how to argue the point. The same thing for arbitrators, how to deal with it. So do you go only through the national law? The national law says nothing. Is it like transnational policy? What do other tribunals say? And thought about this. So I think this kind of, it goes into publications and transparency, but a joint effort, I think, would be helpful at this stage. Just thinking out loudly.
Yes, please.
Thank you. Less a question, more an observation. I very much enjoyed Stephen's reference to a more robust framework for counterclaims. As wishful thinking that may be sometimes, given that it has a lot of coordination and implications and also cost implications for states. There are just a few observations I wanted to make, because I have myself also launched a counterclaim on the behalf of a state that I found perhaps, well, I'm hoping you might find pertinent. The first observation is that Some investments are relatively broad in scope and not always fully understood, and the investor's performance is not always fully understood in a coordinated way by the state. An investment arbitration is almost always an opportunity for an investor's conduct to be comprehensively scrutinized, and for states to determine what in fact misconduct, if any, an investor has engaged in. And additionally, the prospect of a counterclaim may act as a chilling factor for investors who are not necessarily all, how shall we put it, not only financially stable, but also who have skeletons in their closets. And then the third point, which is related, as we all know, global groups often team up with local groups. And in my experience, there is often a problem of global groups not monitoring well enough what the locals are doing. And they only learn about this in arbitrations. So for all these reasons, I would be very happy to see greater role for counterclaims in investment arbitration, subject to the caveats I said at the outset. Thank you.
Sorry, I just wanted to, I have a radical idea. So the thing about investors is, of course, you know, someone who, like Shell or BP, they have like a fossil fuel company. Of course, they're not going to go to Germany because they know Germany's not going to let them mine. But they'll go to China or Russia, where they don't really care about climate change because they're going through their industrial revolution, right? And so the question I have is, the way that what I picked up was that if climate change is a human rights issue, and we want human rights for everybody in this world, then why don't you just take away the state's sovereignty to deal with environmental law and make it a thing of arbitration? So you can't take it to courts in the states and you just have to arbitrate it. Because that way you're applying it evenly across the whole world, because you can't, we might not be polluting in Europe, but then they're gonna have pollution in Africa and you're gonna be polluting in China and all these other places. And then you have aspects of people, and if energy is also a human rights thing, you have people who can't even afford fossil fuel. They're burning tires to get heat for the winter. So if it's a human rights thing, then we need to make energy cheaper, and then you need to apply it equally all over the world.
I had a different question that I'll just correlate it to hers. But on the investors, not a radical idea, but I was thinking also, I mean, the duty of care of an investor, when you have also new technologies introduced, and the states themselves haven't established a certain, let's say, how they're going to deal with these new technologies, or how the community views the aspect of this new technology, because they are yet coming into the market, they're yet to be seen in the future, and the consequences of these new technologies. And I think the ECT, in the first panel, we sort of touched upon that, and hydrogen and everything else that we mentioned is these new aspects for the future. And how can then the investors rely on that if you don't yet know what will come in the future on these aspects?
Well, they can't. Business is risky, and it just needs to be factored in. The good thing is, and this is something I will relate to what Galina mentioned also, and in terms of a waterfall effect that comes in with regulations that are in place in other countries. Let's take the new rules from Germany, for example, starting as of January, where there will be quite stringent reporting requirements for the entire supply chain. Now, those rules will not be as applicable to our market, for example, but we do know that statistically a lot of Bosnian businesses have exports to Germany. And as a requirement, to maintain this business, to remain profitable, there will be this waterfall effect, spill over the business requirements, everyday requirements on the businesses. So the business at some point will drive the regulation, because in order to make it sustainable from a business perspective, they will have to ask the regulator, the state, to help out. So sometimes it's driven by the business itself, sometimes it's driven by the state, the experiences that are brought in by the foreign investors. And in that context, you know, when you are doing your business plan, that's something that you have to take into account, the level of risk in terms of the regulation and the absence of it. But I would say that just not being part of EU, for example, for Bosnia, does not necessarily mean that you can count out all the regulations, because you are playing on the global market, something that you cannot exist in an isolated market anymore.
And since this addressed the third question we have heard, third remark we have heard, I would ask the panelists, do you have any remarks on the two questions that were prior to?
I don't think they were questions. I think they were
the remarks. No? Okay, so now we can move on with another question. Yes.
It's not a question. It's three observations on what was said lately, and I have no answer to your proposition to your radical proposition, but just to follow the idea of and what Stephen said at the end, just to remind the real roots of foreign protection, foreign investor protection. It's true that generally we talk about the investor as the bad person in the history between an investor and a host state, but don't forget that those rules of protection of investor have their roots in the protection of the foreigner in the beginning of the last century, because it's really risky for a foreigner to take his money and go and invest in a place where he knows no one, where they did no regulation. So, and in particular, they are the first victim when you have a change in the government, when you have war. So the roots of those rules, you can find them after the First World War, and the same thing after the Second World War. And those are the roots of this rules that we have created, that were created by all the practitioners and the government also of the nationality of those investors who took the risk to go abroad and invest. So today, when we look at it in a very universal world where transnational investment and transactions is quite easy. We can do it just by sending an email, etc. We don't think about the origin of those rules to protect the investor. Then the second observation, it's what you said, Ilya, about the fact that on counterclaims, generally the corporate big firm doesn't know what are the local corporate firms are doing, and this is generally the source of the counterclaim. We have this, I think, also in commercial arbitration, and not only in investment arbitration. We didn't talk about it earlier, I think, and it is the issues, the legal issues raised by the chain of contracts in a construction contract or an energy contract. We will have the intervention of different subcontractors, and those different subcontractors will be bound by different arbitration clauses. And then you have issues because you have an arbitration clause against one party, but the real person, and here I'm talking physical or natural, is not the one that you signed the contract with. The real person who did the wrongful act, the wrongful conduct that created damage to your company, for example, is not the one with whom you have signed the arbitration clause. And then we have to think about how to solve this chain of contracts with respect to ESG. How we are going to include ESG standards, that's fine, but then also how we are going to solve the lack of arbitration clause in some contracts, and how to solve those complex contracts. And the last observation, and then it's just to follow Galina's request about the publication of arbitration awards using ESG, where arbitral tribunal dealt with ESG. And here I want to attract the attention of all practitioners to what Jusmundi is doing and what they did with ICC to publish commercial arbitration awards, although I tried to find some awards with ESG wording while preparing this my panel this morning, and none of them were published. And I tried to contact some institution to get at least some information, even promising just to talk about them based on confidentiality. I don't want to know the parties, but just to know whether you saw in your awards some cases that we can quote and discuss of, and the answer was known, or at least some were very polite. We cannot give you the information because we are bound by confidentiality rules. So that's it. Thank you for your attention.
Thank you for your remarks. Unfortunately, we're out of time. And I, first of all, want to thank the panelists sitting here before you today for their time and for the preparation that went into this. I hope you have all enjoyed the discussion, and thank you all for being with us today. And I invite you to stay a couple of more minutes just for the last remarks and the final address by our colleague Tahira Bradley.
Thank you, Arnella. Thank you to the wonderful panel, and it's wonderful that I have you here now alongside me, so I don't conclude from a lonely perspective. I want to just conclude by expressing my deep gratitude for all of your time, all of your attention. We have unlocked and opened many important topics. We never promised to give you all the answers, but we hope that we opened up enough avenues for you to pursue them and to continue this discussion going forward. One of the most important conclusions we were hoping to draw from all of these panels today is to eliminate this illusion that there is either one side that is bad or the other versus the good, or some victim and somebody who is in a more powerful position. In order to have a successful energy transition, to mitigate climate change risks, to have still all the success and all the benefits that could arise out of this, there has to be a joint effort. And as we are all learning this new language together and understanding all of these complex issues, it's okay if we have some constructive criticism as long as we still pursue the same goals and continue focusing on the progress. So thank you again to all of our generous sponsors. Thank you to all of our guests and panelists and my colleague Armela and Arnella, who were the idea creators of all of this. We also want to thank Irfan and Timur from Matza, who are our digital marketing team. Also a warm thank you to our wonderful volunteers, Ayla, Amela, Leila, and Igor, who are volunteering today, but soon enough we will also be seeing them on these panels, because as you can hear from their questions, they are far ahead of their time in terms of ideas in this topic. I wish you a wonderful evening in Sarajevo. We're very sorry for those of you who travel from the UK, because we have kind of UK weather these past couple of days, but Sarajevo is charming enough, so we know you will still have a good time. And what else to say? We hope to see you again next year. We will definitely be inviting you, and we will look forward to continuing these conversations. Thank you.